that was disposed of by your lordship and Justice Honorable Proceedings Biswas.
Right.
But that has not been complied, and a contempt petition has been filed in the month of November.
You're mentioning the contempt petition?
Yes.
Contempt petition has to be taken by both of us. We'll have to constitute a bench there, and we'll take the mentioning. এটা স্লিপটা নিয়ে নিন। এটা কলকাতা গিয়ে জাস্টিস বিশ্বাসের আমার একটা বেঞ্চ ফর্ম করে এটা শুনতে হবে। হ্যাঁ, প্লিজ হ্যান্ড ওভার। We'll constitute a bench when we go back there with Justice বিশ্বাস. Matt, appeal hearing? Yes, yes. Mention. Yes.
Yesterday I mentioned a second appeal, my lord, the stay application, because it was admitted.
But
my lord, upon perusal of the file, it appears that the Honorable Coordinate Division Bench, my lord, has probably inadvertently, my lord, has recorded appeal everything disposed of. So, my lord, that probably requires to be, appeal was admitted in the same order. In the last sentence, it has been recorded.
It's appearing in today's list, no?
No, it's not. I mentioned it, my lord, I submitted the file. The last sentence.
Oh. We'll keep it as to be mentioned tomorrow.
Lordship, may I be permitted to mention, Lordship? This is an appeal against conviction, Lordship, and the appellant isn't behind the court.
Yes. Yes, Mr. Babu. Yes.
Lordship, appeal was filed on 17/1/25, and it was admitted, and till date it has not come up in the case.
What appeal?
Lordship,
What is the number? It was admitted. Hand over. Yes. Call on the list. Why is it appearing to be mentioned?
My lords, here this application mat had been disposed of by an order dated 15th May 2024. I had taken out the scan application. In the mat application, mat, my lords, the order was to the division bench has relegated me to the appellate authority, and time limit was given for 7 days. Unfortunately, after that, my lords, no appeal could have been preferred. I have taken out the cause, everything I have stated in the petition. I am seeking modification of that order, my lords. But the opposite side is not here, I think.
You have to give a copy.
Yes, that is.
Serve a copy and come back tomorrow. The petition, the appellant stroke petition. You are the appellant.
I'm the appellant.
The appellant stroke petitioner shall serve a copy on the learned advocate who appeared on behalf of the respondent in the appeal regarding pendency of the application, and file a receipt in that regard on the returnable date. Let the matter stand adjourned till July 24th, 2025.
Great.
We are giving you 1 day for.
Great.
Yes. Sorry. July 24 application টা আসবে, application heading আসবে। Yes. How long are you in custody, Mr. Buddha? What is the offense?
302 conviction, imprisonment for life, my lord.
My lord, I am for the state, item number 2.
You are appealing for the state? Yes. Yes, Mr. Bishop.
Yes, item number, is it item number 2?
It is item 2, yes. 2.
My lord, I am appearing on behalf of the state.
What do you say? Because the...
302, my lord, there are 2 witnesses relevant. May I, my lord?
Yes. Yes, we are hearing you only.
My lord, my lord, kindly come to page number 8 of the judgment. PW3, the second paragraph, my lord.
Yes. PW3, heard the shouting.
Page number 8, my lord, PW3, the second paragraph, my lord.
Yes.
She rushed to the PO immediately after the incident, my lord, and saw the accused with a dagger in his hand with a knife, and blood was oozing out from the wounds. Magnifying glass stop.
Mr. Vishwas, if we grant bail, what would be the stringent condition you will be looking out for? If we grant bail.
My lord, the stringent condition, my lord, they will appear before the trial court,
That they have
Um,
to do. That they have to do.
my lord.
Uh,
Apart
trial
from that,
court.
they are local resident, they will not leave. They
Trial
will,
court, Mr. Vishwas, trial court, there is no scope now because trial
there
is
is
over.
no scope, but I have seen orders, my lord, where there must be some restriction must be placed.
Some restraint
There
must be
is
shown. We can ask him to report to the local police station also.
police station also.
Police
15
station
days
also.
once in 15 days, my lord.
All right.
Otherwise, yes, the evidence is shaky. I agree,
Yes,
my lord,
there
but
is
there are two
some,
witnesses which are relevant.
Mr. Puddar will do that. Will grant bail, but 15 day, every 15 days. Every fortnight we'll say this.
My lord.
The appellant is already in custody for over 4 years. Full stop. Since the trial is over and the appeal is pending, and it is unclear as to how soon the appeal can be disposed of, we are of the opinion that bail ought to be granted to the appellant on stringent conditions. Full stop. Accordingly, CRAN one, no, what is the number of this bail application? CRAN 1 of 2025 is allowed, thereby granting bail to the appellant on condition that the appellant meets the officer in charge, stroke inspector in charge of the local police station of his residence every fortnight, once a fortnight. Full stop. The bail shall further be conditional upon the appellant depositing security to the tune of rupees. What did he do? I mean,
My lord, he's very poor person. Whole the trial, he was defended by the legal aid council, my lord.
so what sort of bond?
Register should be 10,000, 20,000, as your lordship, I don't know. Your lordship.
Bond of
Mr.
rupees 10,000.
Shahapurdar is not audible. Mr. Shahapurdar, kindly use the microphone. I am not able to
Bond
hear
of
you.
rupees 10,000 with two sureties, one of whom must be local, to the satisfaction of
Now it will be my lord, SCJM Mathavanga.
ACJM.
Mathavanga.
ACJM Mathabhanga. ACJM Mathabhanga, Pushap. It is made clear that the appellant shall not try to influence the, try to approach the witnesses and or the family of the victim and or attempt to influence the, no question of influencing the trial now, and or to and or try to tamper with evidence in any manner. First up, the appellant shall also not leave the territorial jurisdiction of the local police station without the prior leave of this court.
My lord, let there be a direction for preparation of paper book with a
Very
time
well.
limit, time
Very
frame.
well. High Court Legal Services Authorities. He is represented by
Trial district. Not
no. Who will bear the expenses for preparation of this? Oh, you will. Very well. The appellant shall prepare and file the
criminal cases, all the.
Criminal section will prepare, my lord.
whoever will prepare. Very well. The paper book shall be prepared within 8 weeks. Within 8 weeks, that records are here. The trial court records. Very well. The trial court record shall be brought expeditiously. The paper book shall be the requisite number of paper books shall be prepared within 8 weeks from the date of arrival of the trial court records. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready. Thank you. Next.
Obliged, lordship.
Thank you, sir.
I'm for the appeal.
What was the offense? How long are you in custody?
It's under section 6 of the POCSO Act, 10 years lordship.
You are in custody for?
2018.
7 বছর আছে। বেশি লোক period
I have served the victim.
What is the sentence given to you?
10 years.
7
10
years.
years, Lordship. And a fine of
वो
1
हाफे
lakh.
बेशी कर रहे हैं। You will not go into, you will reside in the same jurisdiction as the victim.
People statement is there, Lordship, and the evidence of the victim. And plus, Lordship, in this case, Lordship, the victim needs to be served, Lordship. Because it
Victim is to be saved,
served, Lordship.
served, yes, right. You will direct that and you will not approach the vicinity of the victim or her family. The appellant is in custody for 7 years, about 7 years, full stop, since more than half of the sentence has been spent by the appellant behind the bars, comma, we are of the opinion that bail ought to be granted. Full stop, next para. Accordingly, CRAN 2 of 2025 is allowed, comma, thereby granting bail to the appellant on condition that the appellant shall, on condition of uh, security to the tune of rupees 10,000 with two sureties of bond of rupees 10,000 with two sureties of like amount each, one who must be local, full stop. The appellant shall not, comma, in any manner, comma, attempt to approach the victim or her family, full stop. The appellant shall, comma, further, comma, not leave the territorial jurisdiction of the police station of his residence during the period of appeal and make himself available in the event uh, uh, so called for by the appellate court. The notice of the appeal be issued to the victim. The trial court records be brought expeditiously. The requisite number of paper books shall be prepared within 8 weeks from the date of arrival of the trial court records.
Paying for months, service upon victim not completed.
আচ্ছা, এটা on the prayer of the appellant, the matter is adjourned till July 28, 2025.
I run for the appeal and Lordship. So it is that matter was sub notice upon my land friend, Lordship. Yesterday, the matter was taken.
What is the delay you said?
The delay is 8 days delay. The District Legal Service Authority matter, Lordship, the problem is that application for condonation of delay could not be filed because nobody of the appellant had turn up to affirm the petition.
Mr. Laksham, this is a difficulty which some of these people are facing. So we were intending to allow the on oral prayer. Thank you so much. Fair of you. Learned counsel appearing for the appellant submits that the appellant's relatives, comma, who were to affirm an application for condonation of delay in preferring the appeal, comma, have not made themselves available, comma, due to which the application for condonation of delay could not be filed. Full stop. The delay is of about 8 days. Full stop. We find upon hearing learned counsel for the parties that there is sufficient explanation for the delay, comma, since the matter pertains to a legal aid, since this is a legal aid matter and the appellant, comma, being in custody, comma, might not have been in a position to take appropriate steps in time to prefer the appeal. Full stop. Accordingly, on the oral prayer of the appellant, comma, the delay in preferring the appeal is condoned. The appeal is admitted and shall be heard on the grounds taken in the memorandum of appeal. Issue usual notices. The trial court records be called for. Acha. Leave. Leave is granted to the appellant to file an appropriate application for suspension of sentence and or bail during pendency of the appeal. Thank you. Mr. Abhishek Sarkar was given appointment. Can you inform him? We'll pass it over. You are Mr. Sarkar? Very well.
Lordship, I have not received any paper booklet.
6.
Admission of criminal appeal, admitted.
Admission. Very well. You appear here. We'll record your appearance. The appeal will be heard on the grounds taken in the memorandum of appeal. Issue usual notices. Records be called for. Leave is granted to the appellant to file an appropriate application for suspension of sentence stroke bail during pendency of the appeal.
Number 7. When I'm for the appeal application. It's a defective show.
What is the defect?
A delay application has to go.
So you
The victim before the lodge. Preparing the appeal.
this is against an acquittal. So then you file an appropriate application.
Lordship, liberty may be given to file.
The section 5 no liberty is given. We find that there is a delay of about 47 days in preferring the appeal. Full stop. On the prayer of learned counsel for the appellant, liberty is granted to the appellant to file an appropriate application for condonation of delay.
My lord, I have heard the appellant, my lord. My lord,
What is the defect?
Section 5, my lord.
Section 5.
Already filed, my lord.
Why 2 crans?
Grant to, my lord, suspension of sentence, my lord.
Achha. What is the delay?
74 days of delay, my lord.
Reason?
My lord, for obtaining certified copy and legal opinion, my lord.
Legal opinion. POXO.
POXO 4, my lord. Convicted, 10 years and fine of 10,000 rupees, my lord.
How long are you in prison?
4 years, my lord. 4 years, 3 months.
What was the age of the victim?
Victim 17 plus, my lord.
17 plus.
17 plus.
What is your age?
At the time of 38, now 42, my lord.
We will. What do you say, Mr. Lakshmi? Like the previous one. Yes. In view of the grounds made out in the application, we find that sufficient explanation for the delay in preferring the appeal has been made out, inasmuch as there was some delay in obtaining legal advice, more so since the appellant has been in custody during the relevant period. Push up, CRAN 1 of 2025 is accordingly allowed, thereby condoning the delay in preferring CRA DB 38 of 2025. Push up, CRAN 2 of 2025 is an application for bail in connection with appeal. Push up, next para. We are apprised that the appellant is already in custody for about 4 years, 3 months.
3 months.
3 months. Full stop, next para. Giving our anxious consideration to the facts of the case, and also that the appeal might take some time to be disposed of, we are of the opinion that the appellant is entitled to bail. Full stop. Accordingly, CRAN 2 of 2025 is allowed, thereby granting bail to the appellant, subject to putting in bond of a bond of rupees 10,000 with 2 sureties of like amount each, one of whom must be local, and the further condition that the appellant shall not, in any manner, you reside in the same jurisdiction of as the victim.
Yes, ma'am.
Shall not in any manner try to approach the victim or her family during the entire period of pendency of the appeal. Full stop. This much. The appellant shall not also make any attempt to influence any of the to influence or approach any of the witnesses and or issue any threats to such witnesses and or tamper the evidence during pendency of the appeal.
That's all, my lord.
Thank you. ও অ্যাপিল ফর্মাল আচ্ছা যেটা ক্র্যান 2টা বললাম না, ক্র্যান 2 এর আগে মাঝখানে দি অ্যাপিল উইল বি, যেখানে ডিলেটা কন্ডোন করলাম তারপরে দি অ্যাপিল is admitted and shall be heard on the grounds taken in the memorandum of appeal. Issue usual notices. The trial court records be called for. Thank you. ওটা মাঝখানে ঢুকে যাবে, তারপর ক্র্যান 2. Yes.
the time for the appeal. Admission of appeal.
How long are you in there is no application for suspension as well.
And but
Leave, yes. The appeal is admitted and shall be heard on the grounds taken in the memorandum of appeal. Issue usual notices. Trial court records be called for. Leave is granted to the appellant to file an application for bail stroke suspension of sentence in connection with the appeal. Thank you. What is the defect, Mr. Poddar? Out of time. Section 5 is there. Let us see whether there is any other defect. Judges of both the courts below names you had to put in the preamble, and date of signing of decree of both the courts below. Acha, in the preamble, Mr. Poddar, it's a general thing. I mean, don't date of judgment as per order 20 is a date of decree. So you don't put in that extra thing and decree dated such and such. Judgment and decree dated is the date of the judgment. It's a general thing, you just circulate among. We see this in many of these appeals. Judgment and decree dated, suppose the judgment is June 30th and decree dated will be scored through. You make it judgment and decree dated, no, judgment and decree dated 30th June 2022 and 14th July will go off in both the courts. So you correct that also. And the third defect is, name of the plaintiff appellant number 17 in the court of appeal below is not there. You have not implemented 17 in the.
Check the, given liberty, I will.
No, you amend the cause title and very well. Leave is granted to the learned advocate and record for the appellant to carry out the necessary corrections in the memorandum of appeal to rectify the defects during the course of the day. What is the delay? 243 days. What is the explanation? Have you served copy? That means there is no explanation. Oh, since now the appellant shall serve copies of the how many appellants and how many respondents? Appellants shall serve copies of the application bearing can 1 of 2024 on the respondents. When should you direct it to come? Indicating that the matter shall next be listed on July 29, 2025, when an affidavit of service shall be filed by the appellant. We are treating these as applications in connection with the appeal, because sending it to the our own single bench and again taking the uses. Defect Section 5 আছে connection. Leave is granted, none appears for the parties at the time of call. Leave is granted to the learned advocate for the appellant to carry out the necessary corrections in the memorandum of appeal to rectify the defects as pointed out by the stamp reporter. The appellant shall serve a copy of Can 1 of 2024 on the respondent, indicating that the application shall be listed with the appeal in the next circuit when an affidavit of service shall be filed by the appellant. Who is appearing? Yes. No, there's a section 5 application also. Is there any section 5? There's a delay. Section 5 আছে এটা? রয়েছে? Application নেই তো section. Section 5 কোন application তো নেই. You have to file a section 5 also. Leave is granted to the learned advocate on record for the appellant to carry out the necessary corrections to the memorandum of appeal to rectify the defects as pointed out by the stamp reporter. Possibly leave is also granted to the appellant to file an application for condonation of delay. Liberty to mention the application along with the appeal at the As and when the same is filed, let the matter go out of the list for the present. File with section 5, then mention.
Lordship, I put the appellate.
Let us see the defect first.
Lordship, I'll correct the necessary.
Let's see what is the nature of the defect. The dates given for issuance of certified copies are incorrect, appears to be. অ্যাপ্লাই করেছে তিনি, হ্যাঁ। একটাই শুধু ভুল আছে, 13-2টায় ভুল আছে। দেখুন আপনি লাস্ট ডেটটায় শুধু 13-2 করে ফেলেছে, বাকি সব 3-3-3-3 হয়ে যাবে। যদি 5-3-এ করে তাহলে 13-2 তো দিতে হবে না, সবকিছু দেখলে বোঝা যায় 13-3-এ দিয়েছে। 13-3-এ যদি দিয়ে থাকে, when was the appeal filed?
Yes,
Let us-
section 5 application has been filed.
What is the delay?
Lordship, 58 days.
Reason?
Lordship,
You're appearing for the other side?
But since it is at the admission stage, the delay.
No, section 5.
Has to have this intervention.
No, delay is generally heard by single benches, but we treat it to be, because we have determination to get order 41 and connected applications. Again, sending to myself and allowing and returning here. What is your objection to the condemnation? We intend to decide the section 5, and if we allow the condemnation, then take up the appeal for it.
I didn't serve a copy because I don't have the copy. They have not served the.
Acha, the appellant shall serve a copy on the learned advocate, Mr. Pal, who has instruction to appear for the respondents during the course of the day. The matter be taken up tomorrow. Matter shall be taken up tomorrow.
Lordship, the defects to be corrected.
Defect cannot be cured right now because the defect is in the certified copy itself. We'll have to send down.
Lordship.
After the section 5 hearing and order 41 hearing, if we admit the appeal, then we'll send down.
Grateful. Lordship, this matter can it be taken up day after tomorrow, Lordship?
Why?
Lordship,
Defect, let us see the defect. You can rectify the defects.
Lordship, item number 13. Lordship.
13,
Yes,
I am appealing for that.
the previous one.
yes, yes.
Why day after tomorrow?
Lordship, I have to communicate
To whom?
my senior. Lordship.
No, communicate today by phone. Go out and communicate. Yes, next matter, you are appearing for the appellant. Cure defects means there are several defects, but otherwise it's court fees have to be put in, 16 rupees only. Preamble, trial court judge you have not given the name of the trial court judge. But what about the delay? Is there a section 5 application?
There are 65 applications, my lord. Kindly keep it tomorrow. You,
Leave is granted to the learned advocate on record for the appellant to rectify the defects in the memorandum of appeal. The matter is adjourned till tomorrow. Please check up and rectify the defects. The name of the trial court judges you just ascertain and put it in. Certified copy দেয়নি? Certified copy দেয়নি? Defect কি পেতে দেখলাম না সেরকম কিছু। সেকেন্ড জাজিস কপিতে তো না, অরিজিনাল সার্টিফিকেট কপি তো এখানে আছে, হ্যাঁ। ও decree has not been. In the previous matter, you also have to file a certified copy of the decree. Certified copy of the appellate court's decree has to be filed. Certified copy of judgment you have filed. Decree of the lower appellate court you have not filed. Check up whether it's with you. কিন্তু এটা কি? না, degree in suit.
get the receipt of the title suit and the judgment that has been passed in the title of the.
Title appeals judgment has been given, but decree is not there. Trial court both are there. Judgment. Decree certified copy of the appeal which you are, the judgment which you are challenging. Judgment you have annexed, certified copy of the decree has to be filed. Adjourn for the day না করে না ওটা করে দাও adjourn till July 28, 2025. আরেকটা লাইন অ্যাড করে দাও the appellant shall file a certified copy of the decree of the first appellate court on the returnable date. Please take a certified copy of the decree. Check up. And memorandum we have given you liberty, correct. But the certified copy of the decree of the first appellate court has to be put in also. Yes, next.
Praying for adjournment for this week.
Why?
So there is a condemnation of delay application. The service is not effective to the opposite parties.
Did we direct you to serve?
I have served to the opposite party, but it is not.
Without a direction, your service won't mean anything. Well, the appellant shall serve how many respondents?
Served to the opposite party, but it is not received yet.
You cannot serve. Your service without a direction of court is invalid in the eye of law. Unless the court directs, you cannot serve. Even if you serve, if they appear, then it's all right. Because both sides are appearing, we can take up. But if they don't appear, we cannot look into that affidavit of service because that was without the direction of court. To expedite a matter, you can serve, take a chance. If they appear, then it's all right. Both sides appearing, we can take up. But if they don't appear, that affidavit of service does not have any effect. Because the original rules were to issue a rule through the court. That cannot be done unless the court directs. So we are formally directing you.
Generally, we normally make it not today.
The appellant shall serve a copy of the application. What is the CAN number of CAN 1 of 2025 on the plaintiff stroke respondent number 1 and file an affidavit of service on the returnable date. The matter be listed on July 28, 2025, Monday. Did you get our point? What about service? Without direction, because the rules still say that rule has to be issued. Rule cannot be issued without the direction of court. We have substituted that to expedite the matters by directing you to serve by post. So that's a substitution. But if you serve, they don't appear, then that's not a good service. If they appear even then, that's not a good service. But since both sides are appearing, we can take up the matter. Very well. Yes, next. 16.
Appellant's minutes. Section 5 has been filed minutes with affidavit of service.
Let us see whether there is any other defect. You have not given the date of the judgment of the trial court? Oh, you have corrected that subsequently. Leave was granted by the court. No, one correction you have to make.
It's probably minutes, it's appearing for the first time.
Not to question of first time. No, office reported to bhul ache. You have to make two corrections. One is that the judgment and degree date, judgment date of the trial court's order, the first court's order, that is missing. In the preamble of the memorandum, here you have to put in that date, like the judgment of the appeal court you have put in, judgment dated such and such. And secondly, the classification of the appeal will not be memorandum of appeal from judgment and degree, memorandum of appeal from appellate decree, right? So we are giving you liberty, you can do it right now. And if you're the section 5, have you served on the other side?
The intimation is minutes, the intimation.
Was there a direction of court? Was there a direction of court to serve?
No minutes.
Serve, we'll direct you. Leave is granted to the learned advocate on record for the appellant to carry out the necessary corrections to the memorandum of appeal to remove the defects as pointed out by the stamp reporter. Stop. The appellant shall serve a copy of the application for condonation of delay on the respondent, indicating that the matter shall next be listed on July 29, 2025, when an affidavit of service to that effect shall be filed. Carry out the correction immediately and we'll put it on July 29.
As if I may file this affidavit of service minutes?
No, you cannot, because we cannot look into that. If we did not direct it, it cannot be looked. Keep it with you. Yes. Every matter is defective. Why, Ms. Hanus? Some misconceptions are,
Of appeal.
let us check up names of the performer. No, names of the pro forma respondents do not tally with the certified copy of the appellate's court degree. Deceased respondent number 1 and 2 have to be deleted. Respondent numbers 1 and 2 have died. Yes, you have written in your cost title since deceased was you have impleted them.
Like this pattern.
No, but even then, no. You don't put number to them, put a number to them. You write like, say, within bracket, Miss Mosammat Halima Bibi, since deceased, substituted by her heirs, and then. So don't, you have given numbers to their names, right? So respondent number 1 is a deceased, respondent number 2 is a deceased. Suppose we direct you to serve notice, the office will try to serve notice on 1 and 2 on all the numbered respondents. You don't number them, Ms. Neha Somish. You just write here without numbering them within bracket. You just write because it has to tally with the trial court or the appellate court. You say Mosammat Halima Bibi within bracket since deceased, substituted by her heirs. This much. Don't give a number. Don't put a number to her name. And then the numbering will start from the living persons. 1 and 2 names you have to delete. Respondent numbers 1 and 2, and same thing with Mosammat Aisha Bewa. You just delete her number. Yes. Respondents 1 and 2, you have to do what we said. And regarding appellant number 1, just delete the number 1 before her name. So that can be taken care of, and there is a delay also. 123 days. That's the stamp reporter's report. It says there is a delay. Let us check up. 2024, 19,000. Yes, there appears to be a delay. Leave is granted to the learned advocate on record for the appellant to carry out the necessary corrections in the memorandum of appeal during the course of the day. Leave is also granted to the appellants to file an application for condonation of delay in preferring the appeal. This also stamp report has not stated probably memorandum of appeal from yes. Matter cannot, because matter goes out of the list. Let the matter go out of the list with liberty to mention as and when the condonation application is filed. Very short passover.
My opinion.
Yes. Yes, Mr. Otaji, what is the matter?
The appellant plaintiffs, my lord.
Must have lost in both the courts, Philo.
No. Voted in favor, reversed.
You are the plaintiff.
I am the plaintiff.
Achha, what was the suit for?
Suit for, my lord, declaration of my title and prayer for a permanent injunction upon the defendants.
Why was it reversed by the appellate court?
My lord, the appellate court, my lord, found that I could not prove my title.
It's a question of fact. Why should we?
My lord, just briefly appraise the lordship of the fact, my lord.
Yes.
My predecessor in interest, my lord, had claimed title of that suit property by way of adverse possession from another person.
Great. This is the first suit which has been decreed on the ground of adverse possession.
Partly. And then, my lord, by way of 3 deeds, 2 deed of gift and 1 registered deed, my lord, my predecessor in interest purchased about 4 katas, 5 dhurs of land.
From whom? The true owner? Against whom you were in?
10 from the person from whom, my lord, I had, against whom I had
adverse possession. And 2 from others. Very well.
adverse possession, and 2 from others. 2 from the person from whom, my lord, I had, against whom I had adverse possession. 2 from others. Very well. 2 from the person from whom I had adverse possession, and 2 from others. Very well. And there, my lord, the mutation was done in my name and
Your predecessor's name.
yes, my predecessors.
So there are registered deeds.
There are registered.
Very well
deeds.
then.
Now I have, my lord, filed a declaration of my title with respect to the suit property, and that is that property, my lord.
You are claiming by inheritance, or you purchased from that predecessor?
No, inheritance.
Very well
No,
then.
at the trial court, my lord, my predecessor in interest was there. He has, by way of purchase.
Substituted, yes.
And the defendants, my lord, they say that in the written statement that out of that portion, they have purchased one kata 12
Before or after you?
after me.
Acha.
And my lord, in the written statement,
Yes.
the defendants have said that they have no claim over or dispute over my title in respect of the suit property.
Then what are they claiming?
They are saying
Different portion.
that is not clear, my lord.
So how did the appeal court deal with it?
My lord, first is the judgment of the learned trial court, and then, my lord, the appellate court's first appellate court's judgment has been.
No, the appeal court, let us see.
Yes, my
You are
lord.
more interested in the appeal court because it went against you, obvious reasons. So how was it? Because one court has found in your favor.
Yes.
So let us see
And-
why
and
the appeal.
Another issue, my lord,
Yes.
the defendants have claimed title by way of a registered deed.
Hmm.
Another deed was exhibited. Not even that deed was exhibited.
Let us see the appeal court.
But since it is not paginated, my lord, I cannot.
Yes, it's paginated. At the top right hand, appeal court.
Yes.
7 of 11.
Sorry.
7 of 11, internal page.
Yes, so it is there, but
Refer to the internal page. Adverse person, the court proceeding on the premise of adverse person. Why did you bring in the story of adverse person at all?
that is not very clear, my lord, to me also from the.
You claim adverse person simultaneously with deed for the same period. Mutually destructive.
I say, my lord, I was there in the property since 1960. And then from 1977, 76 onwards, my lord, I started purchasing or acquiring title by way of gift.
No, part of the property you have claimed by deeds and part of the property by way of adverse person.
No, the schedule of the plaint is different, my lord. The schedule of the plaint, what the amount of property which I have claimed to be mine, my lord, is by virtue of the registered deeds.
So plain schedule is entirely covered by the deeds.
Yes, my lord.
So what about this 1 kata 7.5 dhurs by way of adverse person?
Yes, that I have claimed, but
That is not a part of the.
my calculation, my lord, I may be wrong, but in my calculation that does not come. But there, my lord, the learned appellate court.
Yes.
Sorry, my lord.
No, you can
The learned appellate court, my lord, found that I am the owner of the scheduled land, which was not even objected.
Omnibus schedule of suit property not describing properties purchased by 3 deeds.
It is described, my lord, the dependence of
The deeds.
Yes.
That the schedule of the deeds that tallies with the suit property according to you.
Yes, that according to me does. I can again come back with fresh
In the-
calculation, my lord. So these were also exhibited.
By non-joinder of necessary party also.
Yes. Now here, my lord, to ground the learned first appellate court took that since the person from whom, my lord, I had claimed adverse possession, his legal heirs were not made parties, and the defendant's case of the defendant is that they are a club. The deed through which, my lord, they are claiming title was purchased by the president of the club. So the club has not been made a party, but the other office bearers have been made a party. Now that deed has not even been exhibited, my lord.
The admit karo dichi. The present second appeal will be heard on the following substantial questions of law. 1. Whether the learned judge of the first appellate court substantially erred in law in holding that the suit is bad for non-joinder of necessary parties, comma, since as per the defense claim, comma, the suit property was purchased in the name of the president of the defendant club and, comma, as such, the club itself could not be a necessary party, as well as since the uh, successors of the predecessor in interest of the appellant's predecessor in interest could not have been a necessary party in view of the in view of the suit property having been transferred by their predecessor in interest in favor of the appellant's predecessor. Next, whether the learned first appellate judge substantially erred in law in reversing the findings of the learned trial judge as to the title of the plaintiff appellants, comma, in view of the plaintiff appellants having exhibited sale deeds in favor of their predecessor in interest, comma, thereby rendering academic the claim of previous adverse position. Third, whether the learned first appellate judge substantially erred in law in overlooking the fact that the registered deed which was referred to by the defendants in their written statement was different from that marked as exhibit on behalf of the defendants stroke respondents. Our fourth হচ্ছে whether the learned first appellate judge overlooked the virtual admission of the title of the plaintiff stroke appellants with regard to the suit property, comma, thereby committing a perversity. Yes, any interim application is there?
Yes, it was filed yesterday, my lord, Can 1.
Then it goes before the single judge. Oh, Can 1 is here before us.
It has come before your lord. My lord, one thing,
Yes.
claiming title not only through registered sale deed, but also gift deed, my lord. My lord has been pleased to.
আচ্ছা যেখানে সেল ডিড বলেছি যেখানে যেখানে ওখানে ট্রান্সফার ডিডস করে ডান ইয়েস হোয়াট ইজ দিস স্টে stay what would be the effect of your declaration of title is there and your permanent injunction is revived?
More so with the declaration of title, my lord.
No, permanent injunction also because it's a restraint order if it very well. There shall be stay of operation of the impugned judgment and degree of the first appellate court till disposal of the application. The appellant shall serve copies of the of Can 1 of 2025. What about why pro forma defendants? They are no relief. Acha, serve your co-legal yes. Serve copies of Can 1 of 2025 on the defendant stroke respondent numbers 1 to 3, indicating that the application shall next be listed before the appropriate learned single judge having determination in the next circuit, subject to being mentioned by the parties. Full stop. Service of notice on the pro forma defendant stroke pro forma respondent numbers 4 to 7 is dispensed with for the present. The appellants shall file an affidavit of service to that effect on the returnable date. Thank you.
Great.
Next. Injunction appeal.
An appeal, my lord, against an order, my lord, appointing a receiver.
Achha, this has been appointed.
It has been appointed. The my lord, from the impugned order,
My lord, first starting my colleague brother.
there was some caveat, they have already been served.
Yes, lordships.
Then
Lordships, my senior had been to the Calcutta for treatment purpose. He will come day after tomorrow. Can it be fixed on Monday, lordships?
subject to what, Mr. Kus?
I have difficulty, let
But-
the order be.
But
My lord, the order is very serious and
lordship,
suffers from patent
nothing will be
perversity.
changed. Nothing.
The
will be
receiver
changed.
has
Only
not
2 days,
not yet
the person-
taken.
Receiver appointed in respect of what?
Respect of a running business, which I am running since 2006. It's a bar cum foreign liquor op shop. Where at the court, they're protected by an order of injunction. No third party interest would be created.
Lordships,
Despite
Actually,
that order,
my senior
Millard,
is conducting the case. I don't have any.
the court has.
See,
That's why I just, 2 days accommodation, the personal difficulties, actually.
that is being opposed by Mr. Ghosh because he's saying that
I'm opposing, Millard, so far as the ground.
opposing
is
for the
concerned,
client, not
there's nothing.
opposing you.
There's nothing so far as the ground is concerned. I'm only praying till the time, Millard, he
We
appeals.
cannot stay unless you admit the appeal and formally grant a stay.
He has me.
Admission,
There's a
let,
first appeal, Millard.
first miscellaneous appeal, but we have to be, if it's patently appeal,
I'm showing it's patently perverse.
so let us see.
Yes,
Yes, then he'll be here for the limited purpose.
Yes.
While taking up the step, if we admit the appeal, generally first miscellaneous appeals are admitted. If we admit the appeal and we grant an injunction or stay, it will be for a very limited period till your senior comes and will.
My submission is, don't have any knowledge regarding the case trial court proceedings. Lordship.
You prepare yourself during the course of the day, Mr. Ghosh, come back tomorrow at least.
It is very
Come.
difficult for me, Lordship. That's why just 2 day
No,
accommodation.
no. They have extreme urgency. Running business, they are saying.
Lordship, it is but joint property. Joint.
No, if they,
Declaration.
if the appellant insists upon moving the matter on ground of urgency, we cannot entertain your prayer for time. No, could be, but cannot now. Yes, Mr. Ghosh, what is the matter?
Kindly takes the impugned order once.
Yes.
Well, first I will take your lordship to the plaint. What they have sought for in the in their plaint.
Yes.
It was, Millard, amended twice. The last amended plaint, Millard, would find at page 44 of the stay application. Millard kindly takes the prayer. A decree for declaration that the defendants number so and so have no right, title, interest and possession in respect of the land, property, business as described below. A decree for declaration that all the properties and business described in the schedule below is the joint property of the plaintiff and the defendant number 1 and 2 and the pro forma defendants number so and so, each having 1/7 share each. So whether it is a joint property or not, Millard, that is a question of trial. Because all those
No, A and B are apparently contradictory.
Well, first is a negative declaration.
Not only a negative, a declare
Yes.
of declaration that defendant numbers 3, 4, oh, acha, 1 and 2.
Yes.
And the rest of the defendants have, acha, very good.
Yes. So whether
Yes.
it's a joint property or not, that is a subject matter of trial.
Right.
Because admittedly, from the deeds in question.
At least joint between plaintiffs and 1, 2, 6 to 10.
Correct.
Yes.
And 1 and 2, defendant number 1 and 2 also, because.
Defendant numbers 1, 2, 6 to 10.
Correct.
That is B.
Yes, because
Yes.
the property.
Joint title admitted, yes.
A substantial portion of the property.
Yes.
Which Millard they are claiming to be the suit property on which the business is running
Huh.
was purchased by the father in the name of my clients. That is defendant number 1 and 2.
That's very good.
Right. Now, Millard, whether that is a Millard joint property or not, Millard knows the principles, Millard, that is a subject matter of trial. Now, once this suit was filed, Millard, they were protected by an order of injunction, which Millard would find at page 148. I'm sorry, Millard, 192. The order of injunction. I'll just place the ordering portion.
Yes.
Both the plaintiff and the defendant are hereby directed to maintain the peaceful possession and status quo in respect of the suit property and not to change, transfer, alienate or create any third party.
Everything
interest
given,
in respect
third
of
party
the suit.
interest, nature, character, everything, yes.
Right. Now, despite this order, they takes out an application under Order 40, Rule 1, which Millard would find at page 194. Now, the first principles on which Millard the court would consider appointment of receiver is the question of urgency, or if not appointed, what prejudice the plaintiff, the other parties will suffer. Not a single line of pleading in the application. Millard is only said, Millard would find.
What is the best ground? Yes.
Ground, Millard, page 20, paragraph 20 at page 198. Paragraph 20, Millard would find one paragraph of pleading with regard to the liquor shop, and Millard para 26. And Millard, in the written objection taken out by us, Millard, we have annexed the documents that the license was obtained in my name. The trade license is my name. Every statutory clearances are in my name. And this is since existence since 2018, which they have acquisitions for at least 6 years.
They're relying on a power of attorney.
That's right. But the power of attorney nowhere says that you go and take the license in all our name in your name. I'll show the
No, power of attorney, they execute a power of attorney. That means you are admitting that they also have title.
Well, 116. It's a shop, it's a running business, and several other portions of the property comprising of shop rooms and where the rents are collected. Milord kindly takes the power of attorney. What was the scope of the power?
Yes.
116. Milord kindly sees whether it has anything to do with the liquor license. 118 from paragraph 1, middle of the page. To appear, represent before us municipal bodies, corporation to make deposit, khazana, so and so, installment, other taxes that may be levied, let out, lease out, monthly tenancy basis, shop rooms, office spaces, residential quarters, to receive salami advances from the tenants, value receipts, so and so. As similar, a big chunk of property comprising of running businesses, hotel, liquor shop, a bar, and other shop rooms also.
The receiver has been sought in respect of what?
Sought in respect of the
Bar.
And the liquor shop. Now, Millard would kindly takes the impugned order.
Yes.
Impugned order, the ordering portion. Internal page 10.
Yes.
Now, Millard would take the prayer in their order 40 rule 1 application. At page 200. What they have sought for. Receiver for the purpose of management, protection, preservation, and realization, and to maintain proper accounts in the business of the hotel, restaurant, bar, liquor off shop, and to deposit the amount to the bank, withdraw the money, payment of the staff, so and so.
Let us see the reasons of the trial.
Yes. Well, I'll show that, Millard, the conclusion and the reasoning of the court is absolutely contradictory rather.
তো কোনো গ্রাউন্ড
My lord, may I?
গ্রাউন্ড যেটা দিয়েছে সেখানে বলছে এদিকে বলছে যে ইস্যুগুলো এভিডেন্স না নিলে হবে না, তারপর বলছে ডিফেন্ডেন্ট কোনো হার্ডশিপ সাফার করবে না, রিভার্স করে দিয়েছে বর্ডেনটা।
Internal page 6, the last line. The court itself says that whether it's a joint property is a matter of evidence. And thereafter,
Even
the court
page 9,
Yes.
while passing the ordering portion also the court says it's a matter of evidence.
absolutely contradictory to the court's own findings. And let why appointment of receiver is required despite there being a protective injunction order, status quo order, that is not clear.
Yes, we'll admit the appeal. You don't have a right of hearing at the admission stage.
Just one day accommodation, Lordship, for
An adjournment is sought by learned counsel appearing for the caveator stroke respondent.
assist properly, Lordship.
Caveator stroke plaintiff stroke respondent. First of, however, learned counsel appearing for the appellant submits that there is extreme urgency in the matter inasmuch as a running business has been interdicted by the impugned order by appointment of a receiver. First of, next para. Upon considering such submissions, we find that indeed, extreme urgency is involved, and accordingly, the prayer for adjournment of the caveator respondent is refused. Full stop, the matter is taken up for hearing under Order 41 Rule 11 of the Code of Civil Procedure. Full stop, next para. The backdrop of the case is that a suit has been filed by the plaintiff stroke respondent number 1 for declaration for a negative declaration that some of the defendants do not have title in the property, for declaration that the property is joint inasmuch as the plaintiffs and the defendant numbers 1 and 2 as well as the pro forma defendants are concerned, further seeking partition as well. For next para, in the said suit, an injunction application was initially filed by the plaintiff stroke respondent number 1, upon which by an order
192.
yes by an order dated October 1 2024, the learned trial judge directed both the plaintiff and defendants to maintain status quo. Now, maintain peaceful possession and status quo in respect of the suit property and not to change, transfer, stroke, alienate or create any third party interest in respect of the suit property and not to change the nature and character of the suit property till disposal of the suit. Full stop. Upon hearing learned counsel for the appellant, we find that the defendant stroke appellants furnished documents to show that they have the license to run a liquor shop hotel from a portion of the suit premises in their name. Full stop. Next para. That apart, the learned trial judge himself or herself, in the impugned order itself, observed that it prima facie appears that the suit property is a common and joint property, but in the same breath, that all such facts are subject to evidence, and without considering the evidence, the court does not find any merit to touch upon and address those issues or to enter into such double inverted legal jugglery, double inverted closed. Full stop. It was further observed that the same has to be decided after evidence being produced in trial. Full stop. Going further, the learned trial judge, in the impugned order, reverts the burden of proof by observing that if an order as prayed for by appointing receiver is granted, the defendants are not likely to suffer any hardship, thereby totally overlooking the fact that the defendants stroke appellants are admittedly at present running the liquor shop and the hotel business, regarding which receiver has been claimed. Push of further, as rightly argued by learned counsel for the appellants, we do not find from the pleadings in the receiver application that any high case of appointment of receiver has been made out. Full stop. In particular, we do not find any urgency to appoint a receiver, in view of there already subsisting a protective order of status quo with regard to the suit property. Full stop. Next para. Moreover, it is well settled that the courts are extremely cautious in appointing receivers in respect of running businesses. Full stop. Next para. Furthermore, we do not find any iota of ground of the level which is required within bracket more than an injunction order bracket court close for appointment of receiver within the four corners of the impugned order. Full stop. Thus, the appeal is required to be heard on the above grounds and the other grounds taken in the memorandum of appeal and is accordingly admitted. Full stop. The application for stay is now taken up for hearing. Whatever you have to say, stay.
So I will bring some documents, Lordships.
We'll give you directly to.
Including, Lordship, only to secure the.
If you want to, we can directly to file affidavit in opposition,
Lordships.
but we'll grant stay. In view of a strong prima facie case having been made out, comma, there shall be stay of operation of the impugned order dated June 18, 2020, impugned order, comma, bearing order number 17 dated June 18, 2025, passed by the learned civil judge senior division at Siliguri in OC partition suit number 180 of 2023 till
Monday, Lordship, Monday we will hear the matter, Lordship. My senior will also come.
till August 31, 2025 or until further order, whichever is earlier. Can you file your opposition within that period?
Lordship, as because Lordship, they are trying to sold out the same properties and they did.
No, that's a different question. There is already status quo.
So at
Subject to Lordship's consideration, all the papers are before your Lordship. Milord, without dispensing with the paperwork, Milord can hear and dispose it of next.
Lordship, regarding the.
All the papers are here, then we will.
Sir, here. If they want to find something, let them bring.
Actually, Lordship, I just informed by my senior Lordship, one day accommodation.
Who is your senior?
Arun Sarkar.
In view of the short conspectus of the appeal, comma, let the appeal along with the application be listed together for hearing on July 28, Monday, July 28, 2025. Full stop. It is understood that the appeal shall be heard on the papers already before this court. Full stop. In the event the plaintiff stroke respondent number 1 seeks to use any further document which was a part of the trial court records at this stage, at the stage of passing of the impugned order, comma, it will be open to the plaintiff stroke respondent number 1 to produce such document produce sufficient copies of such documents at the time of hearing upon prior service of copies thereof on the learned advocate for the appellants. Full stop. In view of the relief being sought only against the plaintiff stroke respondent number 1, comma, service of notice on the pro forma respondents is dispensed with. Thank you.
Great.
Affidavit of service filed today be kept on record যদি না বলে থাকি এটা application heading এই থাকবে. We understanding it will appear under the application heading, otherwise it will never be taken up.
That's what gone through. Milord has given us the stay till Milord has probably.
Stay till August 31, 2025 or until further order, whichever is earlier.
Extremely.
Yes,
I appear for the petitions.
right.
The GST matter, the order of the learned single bench dated 2nd of August 24 is impugned. The issue is regarding Lordship's refund. Section 54 of the GST Act, Lordship, is a code which deals with the entire process of refund.
In matter appeals, is there a formal order of admission required?
So not required, but there is been the directions for
Already given.
Already given.
Oh, paper books koi. Din paper book.
But all the matters are all the evidence. We can rely on paper books. I filed both the paper.
Paper book থাকলে paper book টাই দেবেন, easier. What is your other side? You are for the other side? Right. Yes.
There are two issues.
You are Mr. Kanodia or? Yes. Teach us the law because we are not very acquainted on GST. GST is like quantum theory to us. Whoever understands does not. No, you are obviously for that reason only we are asking you to. Yes, just give us a conspectus of the thing first, then we'll look into it. Right.
Under the law provides the procedure of refund. Now, because GST.
So procedure of refund.
One is when goods are exported, and second in case of inverted duty structure. Inverted duty structure would mean when the rate of input tax, my purchases is more than my output tax GST. So say my output is 18% GST, but my input is 28% GST. So the law provides, okay, because it's an inversion, we will grant you refund. But the case before your Lordship is only regarding exports.
What portion is refunded? The difference.
Law. But our case, Lordship, relates only to refund on account of export of goods.
Very well.
So export of those lordships under section 16 of IGST Act
Yes.
and read with section 54 of the CGST Act, the procedures are provided. That one has to apply for.
Export, there is a blanket refund.
There's a blanket. The blanket provided in section 54 is specific.
All right.
Now, section 54 lordship provides the procedure, that is rule 89. So, the law has envisaged a time-bound refund application process to be completed within 60 days from the date of application till the date of process of the refund. Now, lordship, law further in the rules, has given certain mandatory provisions as to natural justice principles. Like you have to put the notice to the other side, you have to issue a show cause and give a 15 days minimum time to reply to the show cause. The note, when I file a refund application, lordship, the law provides that the proper officer has to issue a deficiency memo in case there are any documents further required within 15 days of my filing of the application.
Which application?
Of my refund application, which is RFD01. This is a form.
So first you file the refund application, notice of 15 days for hearing on that. Only then. And what is that called term? Deficiency? So that deficiency memo itself is the notice.
Memo is issued, then I have to refile the entire application.
All
It
right.
says, okay, these are deficient, therefore you refile. A notice is a show cause notice is subsequent, which after giving an acknowledgement. So if they don't issue a deficiency lordship, they issue an acknowledgement of my refund in RFD02.
So there can be a show cause notice of 15 days even without a deficiency memo.
Lordship. Issuance of acknowledgement.
It's on a lesser deficiency. I mean, what's
You to upload 10 documents,
you have not uploaded.
8 documents.
So that is a deficiency. So then what is a show cause notice? Otherwise, then
Department finds, the proper officer finds, okay, you have availed
Defects.
this input tax credit which is ineligible. You should not have availed this credit itself, it's a block credit. Or
So
this particular export,
Very
as per them is not correct.
for show cause notice, a prima facie opinion formation is necessary.
Issue us the show cause and give us 15 days time minimum to reply.
All right.
Now, and the law says under section 54 that the entire refund process from my filing
60.
60 days. Now, in my case, lordship, I filed a refund application. They did not issue me the acknowledgement. No deficiency was issued. But acknowledgement, which was also to be issued within 15 days, was issued after expiry of 2 days. The law provides you have to issue an acknowledgement, otherwise it deemed to be acknowledged. So, why the law provides that fiscally? Because then the proper officer cannot issue any deficiency further. Therefore, these timelines are mandatory in the statute. Now, they issue me a acknowledgement. After acknowledgement, they keep the refunds with them pending for 47 days. On the 47th day, they issue me a show cause notice, giving me 13 days time to file a reply. And because I was a new exporter, I had new registration, I took time, I sought time from the department to reply to the allegation. There were 3 allegations only raised in the show cause. I uploaded an extension request in the portal. That extension request came to be rejected on the 61st day, stating that this is a time-bound procedure, and because the proper officer needs to pass an order within 60 days, therefore no extension can be granted. So the request for extension comes to be rejected on the 61st day, which itself, as per the petitioner's case, lordship, appellant's case, is they cannot have done that.
The acknowledgement notice is given whenever you file an application for refund. Acknowledgement notice has to be given within 15 days.
If deficiency is issued, I go back to the refund application.
But if acknowledgement is issued, that per se should indicate that there is no deficiency.
Yes. Now the law is also. It is a legal.
So here no deficiency notice was issued at all. Acknowledgement notice issued 2 days after. Law deems that after 15 days it's an acknowledgement. Very well. Even after 2 days it was given. Acknowledgement notice was given without pointing out any deficiency, discrepancy. And after 47
day, the show cause notice in RFD 08, which is a form in the portal.
So that's on a deficiency.
That's on the issues which the department says while scrutinizing my refund application, they come out with certain new issues.
For that, they have to give you a 15 days hearing, notice, show cause notice. But they gave you 13 days only. Well,
Extension lordships. Because for me, new issues were raised. I sought for an extension.
extension is there in provision, either to grant or to refuse, or not granted. Neither way. All right.
I can refuse this to grant an extension on the 61st day. And on the same day, he passes a rejection order.
Acha. So no hearing was effectively given to you.
Because when I sought for an extension, it got.
You sought for the extension to file your reply to the show cause.
That is that we prepared a statutory appeal before the first appellate authority under section 107. Because there was some delay, we first came to this court. This court remanded the single bench, honorable single bench remanded us to the appellate authority by condoning the deal. Now, the first appellate authority, we took points on merits as well as on the question of jurisdiction. As to the proper officer, could the proper officer pass a refund order after expiry of 60 days, that also rejecting my application without giving me proper natural justice rights. The appellate authority lordships improves one step ahead. The original order of the original refund rejection order and says, in the meantime, there was one Saturday, Sunday. Therefore, the proper officer could not have, there were 2 days time limit, delay is justified. And everything lordships by way to state.
The Saturday, Sunday, unless the last day falls on a non-working day.
Everything is for review.
Ah.
I have to file a reply, I have to put on the portal. I did not visit physically. Only personal hearing is given physically, which after 24 has become virtual also.
Right.
So the appellate authority improves one step ahead and says, okay, these 2 days delay, so this is very okay. And I am approving that 2 days delay. He goes one step ahead and says that. Second, he says, on merits, there were only 11 exports which I made during this 3 months period, for which I claimed my refunds. He says that he has received certain information from the Kingdom of Bhutan. This is a third party data. So he should put me to notice. What is that data?
Not given.
Nothing. He relies on that and says, okay, 5 of these invoices are disputed by Kingdom of Bhutan. Exports is governed by Customs Act, and the Customs law says, as soon as I file a shipping bill and I get a LEO copy, let export order copy, it is deemed to be exported out of India. There is no responsibility for me to bring any further document, because my custom authorities is my assessing authority. And the appellate authority improves in the order and says, because customs authority are too much occupied, it is written in the order, too much busy. Therefore, they are not able to verify each and every concern. The state appellate authority casts the observation on the customs officer sitting in the land customs station. Under what authority? Actually, I don't know under what authority, but it is what they have given in the order. So on merits, because they say, okay, there are 2 issues, entire refund got rejected. I will not improve. There can be a situation, lordships, that okay, you find there's a dispute in 3 invoices. But what about next 8 invoices? Out of 11 invoices, the entire refund has been rejected of the 11 invoices which I sought for.
3 were disbelieved.
As per the appellate authority orders, 5 are total disbelieved. For reasons that Kingdom of Bhutan report says something else. Now, I challenge this particular because there is no GST tribunal formed even after 8 years. Under section 112, I come before the writ court.
So let us just formulate for a second. I mean, your one is that acknowledgement was given, that was given beyond the 15 days period. More importantly, acknowledgement notice once issued, that means that they acknowledge that there is no deficiency, but still thereafter they have issued this notice. First, show cause. Secondly, show cause was issued 47 days after the refund application, which was beyond the statutory time. Not beyond the statutory time, but would not leave the 60 days. Very well, because 13 days were given to you to reply only. So it automatically violates that. So the next is that the extension, you sought for an extension given on refused on 61st day. 62nd day. 62nd day. Acha. Thirdly, that Saturday Sunday thing that was added by the appellate court, but that portal driven and all. And next is that Kingdom of Bhutan documents. First, third party document not given to you. Secondly, irrelevant in any event because LEO is what has to be looked into. And lastly, 11 out of 11, 5 were disbelieved. There should have been refund at least regarding the rest 6.
Next 6%. So in this case, that in case of exports, once I file an application, the department has to grant me 90% refund on provisional basis. Then Lordship, they can issue me a show cause and then they can dispute it. 90% refund as per the law, it is a mandatory provision there also.
So nothing was given. Very good.
The original refund rejection order passed on the 62nd day was also on issue which was not ever communicated in show cause.
Alright.
There were certain observations made by the elected proper officer which was never alleged in the show cause notice issued to, which I never responded to. I took time. So order goes beyond the show cause also to some extent. Which section 75 of the law clearly states that the proper officer has to issue an order on the ground specified in the show cause and not beyond.
That's quite obvious in any event in law. Very good.
The report, but there was no GST tribunal. All the appeal order has to be alleged before the GST tribunal.
Now there is a tribunal.
Yes. Even after 8 years, it would have happened. So therefore, report is flooded with writ petition.
Right.
So we came on merits as well as on the point. On the merits of my export refund application version, as well as on the point whether the proper officer and the London appellate authority could have gone beyond the statutory time limit of 60 days as per the section 54.
Yes.
But the London single bench of by order dated 2nd of August 24 made observations on the point that 60 days here, though the word used in the statute is shall, but if 2 days delay is there, it is not
Mandatory. No.
it is not mandatory. It can be read as directly in this case. But on the merits, there is only one paragraph written in the entire order which says on the merits that the observation of the appellate authority is correct. Therefore, the case.
So regarding all the other grounds which you took before us, nothing. Let us see the order once. What is the page number in the paper book? Ask.
Para 14, I would directly take a logic to page 12. Otherwise, that's a discussion on the mandatory and directory part. But para 14.
Para 13 is relevant.
We will start from para 13 since she's. You are for the other side. Yes.
This para.
13 onwards. Yes.
Given cases the proper certified that the person applying for refund has fulfilled all prescribed conditions before making such a demand and the claim of refund is admissible. In this case, the petitioner failed to justify the objection raised in show cause and on the last day of the prescribed period paid for an extension of time to reply. The time period could not have been extended by the authority since the given period as prescribed in Rule 92 of the rules is mandatory and the authority had no power to extend this. So here the letter single says that the time period to reply to the show cause is mandatory. But on the overall object, that 60 days, it is concluded that it is direct. Despite the petitioner being provided with ample opportunity being heard, as has been prescribed under the rule, the petitioner failed to comply with the mandatory time period to reply and the next party order came to be passed. Para 14, the impugned orders are well reasoned and have been passed after taking into account all the relevant consideration. There is no procedure infirmity nor contravention of any law nor erroneous exercise of jurisdiction in passing either of the impugned orders. Therefore, there is nothing on merit which the petitioner has been able to demonstrate warranty. This is the only paragraph regarding my submission, and those are pleadings in the writ petition. Also, there are pleadings to the extent in my appeal petition before the London Appellate Authority. All those things have not been.
Acha, that minimum 15 days period to reply to the show cause notice, that is also statutorily provided. So in any event, you did not get that. If it's on the 47th day and the court says that 62 Rule 92 is mandatory, then that logic, at least by that logic, it should have gone.
Within the issue came before the Honorable Chief Bench was that whether when time limit under section 16(4), just take 2 minutes or two. 16(4) is a provision which provides that whether I can take input tax credit after a cutoff date. The law provides, okay, you have to take ITC in your returns within 30th October of the next financial year. So some SSC took that input tax credit of previous year on 2nd of December of the subsequent year. So notices were issued. So everybody challenged those before the court, and the Honorable Division Bench ruled that the time limit provided in the statute is mandatory. The writ court also cannot tinker with the findings with the timelines. So wherever, Lordship, the timeline, because this entire law is based on timeline procedure law. It's a procedure law, Lordship. I would beg to submit the law based on a procedure.
Now you can show us the provision. Right.
This is a synopsis.
One copy only. You have a soft copy? No difficulty. Marking should be easier for us. What I mean? No. Yes.
First is the synopsis in page number 2. In the second page, Lordship, I have made a table.
Yes.
The RFT one, which is my application, is dated 24/12/2021.
Dates. Huh.
RFT 2, which is 10/1/22, which is beyond the 15 days, 2 days delay. Then, Lordships, RFT 8, 8th of February 22. 47 day they issue me a RFT 8, which is the show cause notice. No justification given as to why they issued me a show cause on the 47th.
No, RFD 2 is the acknowledgement.
RFT 8 is the SCN, show cause notice. And RFT 6 is the final refund rejection.
What is this RFT?
These are portal forms. Everything has to be filed on the portal, Lordships. Along with this forms, there are detailed attachments.
All right.
I have relied in this compilation given today, Lordship, on certain board circular, Lordship, kindly in the page, para number 8, Lordship.
Yes, we've got.
The petitioner submitted responded not by participation for 54, gateway through 92, but also transferred the circular 125 issued by CAC in passing the refund rejection order on a date which is subsequent to the mandatory time limit of 60 days from the date of filing. So 125 is a master circular for refund, which governs how one has to file a refund, what are the documents to be attached with the refund application, and what is the role of the proper officer, and how the proper officer is to deal with the refund, including the issues of deficiency and the show cause. Lordships, when similar
We'll require a copy of the master circular. Rule 92 is with us and the act. If it's there somewhere in this, then it would be. Apparently it is. Yes, something is there. Small print something. No, that's a judgment also. Give us the page number, that will suffice.
Cases where the facts were a bit different, wherein there was no deficiency at all issued, and the 60 days time limit expired and no show cause also issued. The only Delhi High Court has ordered that you have to process the refund along with interest.
After 60 days. They were on a better footing, slightly better footing. He had a show cause. But regarding the timelines, that is relevant. No, not on merits. There's something in between the procedural aspect also. The procedural, they flouted the procedure also. In Delhi High Court, they did not flout the other procedures, only the timeline. But regarding timeline, there also. No, that is what we are saying. Yes. The final timeline of the order, that is relevant to your case. What is the, you have given an index or, yes. Yes, just if you can give us the relevant paragraphs, that would help us. MD Securities, that is. Samrat, where do we find that? Well, yes. Smart Ad Media. Yes.
That is.
In our copy also, yes. If you can give the relevant paragraphs.
Para 7, 6, 7. Your Lordship, in the next judgment of MD securities,
Yes.
the relevant paragraph would be, Lordship, para 4, 11. Para 4 is a detailed para, Lordship, and then para 5, 6, 7. 4 contains the entire reasoning. It's a long para.
All right. This is on?
This is on the timelines. 60 days, both of the 60 days.
Smart ID Media also on timelines. All right. Gion International.
15 days, whether deficiency memo is not issued in 15 days, and what are the consequences? The relevant paragraph would be para 8 to 12.
Right.
So on merits also, the natural justice part I have explained also. On the merits of the matter, I have attached all my shipping bill copies, let export order copies. No, Lordship, going by the department's allegation that unless I prove export, what is the proof of export, Lordship? GST law does not deal with it. One has to go to the Customs Act. And the Customs Act very clearly states down since very long that once I export the goods.
You refer to that section also, that provision also regarding the customs law.
Customs manual, the relevant paragraphs, Lordship, I will send.
With copies to them, obviously.
On the basis of certain document, third party evidence of Kingdom of Bhutan. But I cannot write to Kingdom of Bhutan and get certain documents. My role is up to the land custom station. Once the goods cross land custom station, Lordship, then the importer has to file certain declarations with the government of Bhutan, Kingdom of Bhutan. I cannot chase the importer to get the document. Therefore, Lordship, the question of issuing a show cause notice alleging that these goods have not been exported or export basis certain third party reports, unless putting me to notice, Lordship, the entire process gets fishy. Because I cannot, under the Indian customs law, go to the Kingdom of Bhutan and ask for a document as to what the importer is showing is. And Lordship, customs has never disputed my claims. Because Lordship, for every exports, I am entitled to certain sort of benefits like drawback, duty drawback, and other benefits. And all these goods pass the customs, when it process the customs land station, Lordship, proper officers of the customs are stationed there. So the appellate authority stating in the appeal order that custom officers are too much busy and occupied so that they are not able to check every door.
Late export order is LEO is issued at what stage?
As soon as the goods cross the custom frontier of it.
All right.
Once the shipping bill I can generate sitting in the USA also.
Right.
Shipping bill is not the relevant document. The LEO copy of the shipping bill, it is a proof that the goods have been exported. The entire, in fact, in this entire region, in the Jalpaiguri sector, what is happening that all these exports are being doubted on the ground that certain persons are taking certain unsurplus activities being done by certain class of persons. But for that, every SSC who has the proof of exports cannot be proved. That is all my submission on merits, and I have submitted the export invoices and my shipping bill copies are a part of it.
Let us hear them. Yes.
I need the hearing will be fixed on Monday, and take some time.
Don't do it. Do it this side of the week. Otherwise, we won't be able to pass judgment.
Fine.
We require the weekend for passing judgment.
Fine.
We are not regulars in this in the revenue branch, but it's very interesting apparently. Yes, but that interest would fade away if we won't get the time actually. If we take it on Monday, then we are also fixing death reference matters. That's why this weekend will, in any event, will be hectic. But do it whenever you like. This side, the latest day. Why make it Thursday? Because you have one day in hand. Take instruction. We are on Tuesday. Let us keep it on Thursday. Let us see. If you are in difficulty, we'll keep it on Friday. Absolutely. No difficulty. No. But that customs, those. Yes, that customs, do that. I think it will be easier for us because if you just give the bullet point things. summary, bullet point, only the legal arguments and the relevant law and the extracts of the, or what law is Customs Act. Where will we get that from here? Just give the relevant sections. Very well. Heard learned counsel for the appellant on the prayer of the respondent authorities. The matter is adjourned and shall next be listed for hearing, for further hearing on July 24, 2025. Thank you. Part third matter hearing listed উপরে করে দেবেন তা নাহলে শেষ করতে পারবেন। থাক। জিএসটি লটা এখানেই থাকে এখন। আচ্ছা এইটা না সঙ্গে একটু স্টেবল করে দেবেন। কোথাও একটা এটার সঙ্গে স্টেবল করে দেবেন। উড়ে গেলে কিন্তু গেল পুরোটা। একটা কাগজ স্টেপল করে দিতে হবে। কাগজটা উড়ে যাবে স্টেপ।
22, I am for the.
Yes.
May I submit, my lord, the affidavit in reply? Lordship, I filed the affidavit also.
Right. Opposition and reply. Very well.
My lord, with greatest respect, my lord, learned single judge admitted the writ petition and no stay order passed. Thereafter, my lord, filed appeal and Honorable Division Bench of Honorable Justice Horace Tandon passed the stay order and gave direction for exchange of affidavit. In the, my lord, main fact of the case is that, my lord, this is the GST matter. For the initial year, my lord, 17-18. Initial year 17-18, my lord, they issued intimation. Did not issue, my lord, that return verification notice. Return verification notice is, my lord, under section 61. The form is ASMT 10, rule 99. That was not issued. But this is very important because, my lord, my returns were not verified. Dispute started from here. I initial year.
That was to be done within 15 days.
No. This is normal.
No.
No refund matter. Normal matter. Adjudication under section 7. There are two sections, my lord. For adjudication, I must indicate one is for 73, one is 74. My case falls 73. 73 non-fraud, non-suppression. So they admitted I have no fraud, no suppression. What happened, my lord, in the initial year of GST, there are a lot of confusion, notification, circular, and I deal at works contractor. So I could not receive my bill from government time to time. So, but I have to file return. If I do not file return, they will cancel my registration after 6 months as per provision of law. So I filed GSTR 3B monthly return and GSTR 1 return nil figure. I compiled. But annual return, section 44, my lord, annual return provision. If there is error or I missed something, I can reflect in my annual return. So my PAN, GST is PAN based. And, my lord, I have registration in West Bengal and also other 4 states. What happened, my lord? They issued intimation notice and they have stated in the notice that you have 26 A's. 26 A's, my lord, PAN based all India turnover. Suppose rupees 100, my lord. My West Bengal turnover say rupees 20. So they are saying mismatch. So you have evaded tax. Thereafter, my lord, they issued intimation. I prayed times. 3 times, 3 adjournment prayed. But, my lord, thereafter, show cause notice issue. On medical ground, that I time prayed medical because one director was ill. Later he died, my lord, who looks after the taxation matter. Show cause notice issued. Time given. After expiry of 1 day, on 21st October 2023, I prayed adjournment, saying medical grounds of the director. They passed the order in the month of December, and, my lord, without recording my adjournment prayer. And also in the show cause notice, they have written no personal hearing. On this issue, our division bench, my lord, Honorable Justice SP Keshwani, that set aside for non-granting of personal hearing. But here natural justice two violation. One is not granting of personal hearing,
Hmm.
and second is, my lord, the non-granting of adjournment as per section 75, subsection 5. Law says the adjournment has to be done if sufficient cause shown. So my medical reason, but not recorded in the adjudication order that I prayed adjournment. Thereafter, my lord, the order uploaded in the portal, I prayed, I filed appeal. There is delay of 170 days beyond 3 plus 1 month. 3 months is main period, 1 month is extended period. And all this issue I have raised, ma'am. Thereafter, my lord, appellate authority said I have no power to condone the delay.
Now, after that 3 plus 1, after plus 1, is there any power?
Yes, yes. No, that is not mentioned. And in that case, my lord, our
If it's 3 plus 1, it's obvious. 3, that ordinary time ends, plus 1 is the outer limit.
outer limit.
The
Thereafter-
statute should provide similar, has similar provisions. After that plus 1, you cannot have any.
No, my lord, that is why, my lord, our honorable division bench, headed by Honorable Mr. Justice Devanshu Basak, passed the order in case of, I will show your lordship the judgment.
Yes.
First orally, my lord.
Yes.
That appellate authority have the power to condone the delay. That is, section 5 is not excluded here. Limitation Act not excluded here. I will show your lordship.
All
that
right.
order. Thereafter, my lord, and this order, S.K. Chakraborty, recorded in the learned single judge order. Thereafter, my lord, learned friend relied the S.K. Chakraborty is under pending Supreme Court. Supreme Court granted stay on this issue.
What was held in SK Chakraborty?
Only stay granted is a admission stage, my lord, in Supreme Court. But, my lord,
No, what was held in SK Chakraborty's case?
S.K. Chakraborty is held that the appellate authority have the power to condone the delay.
Have the power.
I'll show you.
They granted by Supreme Court.
Supreme Court. Thereafter, my lord, my
SK Chakraborty's Justice Bosak's order.
Just Basa. I'll show you, lord. My
You say that has been stayed by the Supreme Court.
Supreme Court. My lord, your lordship well aware, my lord, that our honorable division bench judgment, my lord, in the case of Piyush Kanti Chaudhary, Niranjan Chatterjee, delivered by our honorable Mr. Justice Bhaskar Bhattacharya, my lord, that mere stay, that not final declaration of your lordship knows, my lord. So, SK Chakraborty judgment, it is binding on us, my lord. And for this reason, my lord, our principal.
We'll have to look into SK Chakraborty. Apparently, because
kindly, I know.
plus 1, if it's 3 plus 1, anyway, we'll look into this.
Kindly, do not.
Was passed by Honorable Justice Devanshu Basak on the point of limitation that whether if it is expressly barred, 29(2) of the limitation. Unless it is expressly barred, limitation provisions of the Limitation Act.
We'll look into that 3 plus 1 section.
I'll show.
Plus 1 is generally couched in a negative language. After that, it will not be entertained. We haven't looked into this statute. We'll look into-
I'll show. My lord,
Thank you.
our honorable division bench and also our honorable principal single bench, my lord, till date, my lord, relying that judgment and condoning the delay. And so last week I also appeared several matters, my lord. And my lord, our honorable Chief Justice bench held many cases that if there is natural justice violation in the adjudication stage, even there is delay in appeal, remanded the matter to the adjudication. I will show your lordship the judgment. So, my lord, may I first submit that judgment, my lord, our division bench?
SK Chakraborty.
No, my lord, that adjudication part, my lord, for natural justice violation.
First, show us the section, please.
Yes.
Relevant sections.
Section is, my lord, 107. Your lordship have the GST.
Yes. We have that.
May I submit another book, my lord, for
No,
GST?
both of us have.
Yes.
Yes, 107.
107. This is a parameter, state GST and CGST, my lord.
Now, should we look into the State Act then?
Yeah, same. I am also carrying a state act.
No, the section numbers are also identical.
Same. All are parameter.
Copy paste or parameter?
Maybe.
If it's parameter, you have to look into the State Act. State Act টা আনিয়ে নিতে হবে।
No, my lord, this is the latest book, 2025, my lord.
West Bengal, এই যে
No, this is West Bengal book, latest book, just 10 days, 15 days ago published.
color has changed.
The department.
দিন ওর। এইটা একটু আনিয়ে নিতে হবে। হ্যাঁ, এটা একটু হ্যাঁ, দুটো কপি WB GST Act
Subsection 4.
এখানে আছে বলছি। হ্যাঁ হ্যাঁ, এই যে হ্যাঁ, দেখতে দাঁড়ান দেখে দিই। মেঘনাথ এটা ফেরত দিয়ে দে, আমি দেখছি এটা ওইভাবে। We have his color.
2021 book, this is 25. The provision
Is there any changes? Provision is
107. My lord, 107 appeal to appellate authority. May I read from 1, my lord?
Give us just half a second.
May I read from 1, subsection 1?
Yes, yes.
Any person aggrieved by and decision on order passed under section this act, state goods and service tax or union services such as such by adjudication authority may appeal to such appellate authority as may be prescribed within 3 months from the date which said decision order is communicated to such person. Number 2, the commissioner may on his own motion upon request from the commissioner of state tax, commissioner of union territory tax, call for examine record any proceedings in which adjudication authority has passed any decision or order under this act or the State Goods Services Act or the Union Territory Goods Services Act for the purpose satisfying himself as to legality or the propriety of the said decision or order, and may by order direct any officer subordinate to him apply to appellate authority within 6 months. So for me within 3, for them within 6, that was discussed in the SK Chakraborty judgment, my lord. I will show your lordship what that provision. So out of arising, the mass case may be specified by the commissioner in his order. Number 3, where in pursuance of an order, subsection 2, officer makes an application to the appellation shall be dealt by the appellate authority as if were an appeal made against the decision order of the adjudicating authority, and such authorized officer or an appellant provision of the act relating to appeal shall apply to such application. Now 4, the appellate authority may, if he is satisfied that appellate My lord, may I hand over the copy of the SK Chakraborty?
Yes, yes, please.
আপনাকে দিতে হবে রাত দিয়ে দিচ্ছি। And my lord, and the honorable apex court judgment, my lord. Check with them. This is honorable apex court SK Chakraborty. I'll show you, lord. My lord, SK Chakraborty judgment, my lord, para 19 to 23, my lord. And here also, my lord, Kajal Datta judgment of our division.
The premise was that 107 does not specifically exclude, so section 29(2) of Limitation Act is not attracted. That is the premise.
And our division bench, my lord, on medical ground, that also referred here. I will submit that judgment also. Kajal Datta for medical grounds delay condom. Our division bench.
Beyond the 3+1.
Yes.
Beyond 3+1.
3+1.
That was the Chief Justice's order.
Yes.
Cite that first.
SK Chakraborty. And this judgment also recorded by Honorable Justice Harris Tandon in our last order, first the division bench order. Here, my lord, on medical grounds, my lord, that delay condoned and remanded the matter as their merit in that case.
But it is para 5C, cannot be cited.
Yes, that is not, but medical ground. My case is also medical ground. I will show the.
If
medical
a judgment records that this
Yes.
this shall not be treated as a precedent, it does not have any precedent.
Yes, yes. I must indicate. And my lord, another, may I submit the another division bench, other high court where delay condoned, my lord?
Whatever you like, don't ask us.
My lord.
But don't multiply too many. Don't multiply too many.
I have, my lord, 4, 5 high court judgment, my lord. So may I submit all the or 2 or 3, my lord?
2 or 3 of your favorite courts.
Delay condoned. Pawan Fabric, Punjab Maulana, DBA.
Now, where the issue has been decided, don't just cite 1-page, 2-page judgments where the delay was condoned, but this issue was not adjudicated upon. To have precedentiary value, this issue has to be raised, decided, and a ratio laid down thereon.
No, in this, my lord.
Suppose if we just say that yes, delay is condoned beyond 61, 3+1, but we are condoning the delay. No, there the issue has to be decided. Cite those cases only.
My lord, here, my lord.
Like SK Chakraborty clearly decides the issue.
Here, my lord, I said 1, 2, 3, 4, 5, 6 judgment. Delhi High Court, Rajasthan High Court, Andhra Pradesh High Court, Punjab Haryana High Court, and Delhi High Court. They, Honorable High Court held that High Court have the power, if the case has good merit, then High Court have the power in writ jurisdiction to condone the delay. All this judgment held, man. So my case is merit because my.
This is not writ jurisdiction. This is under statutory appeal under a specific provision. So we are governed by the statute. Any of those matters on GST.
GST, all that matter GST. Man.
GST.
Yes.
Don't make us differ with all the high courts. Don't make us differ with all the high courts. This is not writ jurisdiction we are exercising.
Yes, but in this GST matter, they condone the delay.
What is the logic? Side judgments where some ratio was laid down.
This is
and 3+1 matters only. 3+1, 3 months plus 1 month matters only.
Yes, yes, yes. All these issues, my lord. In all 5 cases, my lord.
Yes, yes.
I am carrying.
So you can cite those days.
My lord,
para application
and 6.
manual's application is a regular. So
Para 5, 6.
5, 6. The challenge, yes, you are right, because the statute governs up to that statutory appeal to the appellate authority. You are challenging that under 226. I'm sorry, I whatever I said was wrong, because we are exercising 226 jurisdiction.
My lord, I am
as High Court, we are exercising. It's not a statutory appeal before us, right?
And my lord,
I was wrong there.
2, 3, 4, 5, 6 judgment.
226, it's much more open. 226, it's much more open because 226 remedy is not governed by.
That is why, my lord, our division bench, in spite of delay beyond 3+1 month in 2 matters.
No, but difficulty is in your case.
Remanded the matter to the adjudication.
No, the statutory appeal. In your case, the statutory appeal was filed before the appellate authority after 3+1.
Yes. Here also 5, 6 cases, also 3+1 month. And my lord, importantly, I will show you lordship, my lord,
How,
judgment.
226, we can understand if there is a delay in filing the 226 application. We derive jurisdiction from under 226 up from that stage. But till the statutory appeal, we have to go by the statute because the appeal is a creature of statute. And if there is a provision for appeal, that provision itself governs the modalities of the appeal. That is also quite well settled. Now, there the appellate authority was not exercising 226.
No.
We don't understand this logic. We'll look into this. Definitely, so many high courts have said must be something there.
May I submit all these high court judgment, my lord? One copy, my lord.
Yes.
And my lord, next, my lord, Pawan Fabric, Punjab and Haryana High Court, my lord. ওখানে কি একটা বেশি না? Pawan Fabric, my lord. Here also medical grounds also there, my lord. Para 4, 6, 7, my lord. Para 4, 6, 7.
This writ petition was filed in your case against the appellate authority's order.
Against the appellate authority's order because there is no tribunal till date, my lord. And my lord, may I submit another judgment of Punjab Haryana High Court?
So, where is the provision of challenge before the tribunal? Under which provision?
112, my lord, section 112.
Very well.
My lord, may I submit other judgment? My lord, then, my
On
lord,
same point?
same point.
Need not.
Delhi High Court and others High Court.
You have given one Delhi.
No, I have given Haryana. So Haryana I am not giving. May I submit for Delhi High Court? Rajasthan I have given, my lord.
Rajasthan you have given, yes. Rajasthan you have given, you have also given our High Court and Delhi Delhi give us.
Delhi I am giving, my lord, and the Andhra Pradesh, my lord. All other division, may I submit that Andhra Pradesh judgment.
So then all are covered.
All are covered. Para 11, my lord, here. Muscating. Para 11, my lord. And my lord, the Delhi High Court judgment, my lord, may I submit, my lord? Uh, 6 to 10, my lord, para. In all these cases, my lord,
But we don't understand the logic of these cases. So with utmost respect, the impugned order, all the cases say impugned order under section 107 does not suffer from any illegality.
Yes, yes.
As the appellate authority cannot condone the delay beyond statutory condonability.
But High Court restored the appeal.
So how can we use up the jurisdiction of the appellate authority and act as the appellate authority and do that?
That is held, my lord, on these cases. And our High Court, my lord, in the case of our High Court, what happened, my lord, that natural justice violation in the adjudication remanded the matter to the adjudication, even there is delay in appeal. This is very important for me, my lord, because here, my lord, personal hearing not given. I will show your lordship in the show cause notice that not applicable written. I will show from the brief, my lord. And that judgment, my lord, Mortuja B. Kaukawala. Here, my lord, personal hearing not given, natural justice violation. So there was delay, D plus beyond 1 month and remanded to the adjudication. The entire judgment is applicable, my lord. And my lord, the Delta goods, our High Court, my lord, the entire judgment. And similar point, my lord, that natural justice violation in adjudication, though there is delay 3 plus 1, remanded to the adjudication, my lord. Hey. And my lord, on similar point, may I submit Gujarat High Court judgment, division bench, my lord? Here also, reply not considered in adjudication and ill health remanded to the adjudication, my lord. Para.
Yes.
My lord, Gujarat High Court, CG developers, my lord. This.
Yes.
CG developer, para 10, 15, 27, 28, my lord. 10, 15, 27, 28, my lord. CG developer. Remanded to the adjudication, my lord. Gujarat. Another judgment, Gujarat, so not submitting, my lord.
Not,
On that
same
point,
High
not
Court.
submitting, yes, my lord.
Sufficient, yes.
Others to be repeated. And
Yes.
my lord, importantly on personal hearing, my lord, that the show cause notice, personal hearing column written, not applicable. Our division bench judgment, my lord, may I submit, my lord. Para 7, it is written, not applicable, written in the personal hearing column. I will show your lordship from the brief, my lord. Para 7 onwards, my lord.
Yes.
Now, my lord, may I lordship your at page, my lord, lordship, I am drawing lordship kind attention, page number 77 of the, my lord, stay petition, my lord.
Yes.
Before that, my lord, intimation was issued. I am not going on that part, and I prayed adjournment, they granted adjournment. But show cause notice is important. And show cause notice from middle portion, the brief fact of the case, 26 A's and GSTR 1 mismatch.
This is can 1.
Oh, sorry, cementation, no, 110, my lord, page number. I missed the page number. 110, my lord.
Yes.
Middle portion, my lord, show cause notice. This is the summary of show cause notice. Statutory form is 01. And brief fact, middle portion, my lord, 26 and GSTR 1 mismatch. Now, my lord, section 61 comes. Section 61 says verification of returns. That means they did not issue ASMNT 10. I will show you lordship from rule 10 as per rule 99 section 61. That means they properly not verified my returns. My return means GSTR 3B, GSTR 1 and annual return 99C. Annual return under section 44, my lord. On merit part, my lord, I'll come in.
No, personal hearing is to
Yes,
be given
yes.
under which
And the
provision?
second page, my lord, kindly have a look.
We have seen not available, not applicable.
Not applicable.
Yes.
And my lord, importantly, next page 112, my lord. May I read from second para, my lord?
Yes.
Whereas upon examination of the return GSTR 1 and 3B filed by you for the period 1st July 17 to Atho, because GST started from 1st July, it appears that you have declared nil return of nil return of 59 lakh turnover GST plus SGST lakhs. This is our, my lord, West Bengal turnover reflected in the GSTR 9 that was not written. And upon examination of the third parameter, statement of tax deduction 26 is that your outward supply is 2.7647 lakhs. So this is my all India turnover.
GSTR 9 you have submitted.
Yes, taxes paid. I discharge my all taxes. And it is available in their portal. So on merit, there is no taxes payable. So your lordship knows, my lord, Form 26 is of the Income Tax Department. GST is PAN based. If I have one account at Delhi and one at Punjab, then all bank will report in the 26 is like salary, fixed deposit. So that is the all India based structure. My case is I'm West Bengal registered this number, GST number. So they ought to have considered my annual return under section 44. That is very important on merit. That was not considered. I will show your lordship the relevant provision. Thereafter, ma'am. Page 114, my lord. The screenshot taken from the portal. That, my lord, last column, my lord, personal hearing, no. In the portal also they written that personal hearing, no. Thereafter, my lord, reply to the show cause notice, page 115.
We'll continue tomorrow. 115 now.
Tomorrow, my lord, I have
Difficulty.
Two matters fixed at principal bench, my lord. Then Friday, can it be possible, my lord, subject to law?
We don't know whether we'll be able to pass judgment in so many matters. There's so many judgments you have cited, you have to go through all the judgments.
Yes, yes.
Then kindly fix it on next Tuesday or because I already got
No question of next Tuesday. If you hear it this week, this side of the week, we can only judge.
My lord, subject to correction, my lord. On Wednesday and Thursday, my lord, I have matter fixed before 5 courtroom number 5, my lord.
So we are not marking it as parted, let it be in the list. Although hearing has been commenced, the same cannot be concluded due to paucity of time. Let the matter stand adjourned till Tuesday, till July 29, 2025.
My lord. Then, my lord, on that day, I will submit the provision of law, my lord. Grateful, lord.
Yes.
I'm grateful. Okay.
For my lord, right?
Yes, Mr. Muni.
My lord, fixed on the appeal. More to be heard.
Tomorrow. Yes, Mr. Singhania was there. Mr. Mujumdar, just inform your other side. And when since we have directed, let it come in the list. Just have it mentioned by Mr. Singhania, we'll do that. But just inform your other side.
My lord. Item number 25, I am appearing in income tax matter. Can it be on my Tuesday, my lord? Short issue involved, my lord. 25, my lord.
No further mandamus applications we won't be able to take up further. Because we won't be able to deliver judgments. If it is not, when it is called on tomorrow, ask somebody to pray for time, we'll grant time.
Passover matter.
We can't. When can we take up? It's already, password means not today then. We take up single bench matters after 2.
Plus.
96.
What 96? FMAT CO
CO 96.
as a motion, then listed motion.
We have number. Earlier it came in the list, but the hearing was not taken in motion.
Oh, দেখে বুঝবেন না নিয়ে Yes.
May I have your lordship kindly?
Wait. First the physical mentionings. Yes.
Permitted to mention one item CO, what, 140 or
Yes.
24 is not included in the list where read for inclusion in the list.
Right. Hand over. Yes. What is that?
For a mention of scan application.
Why are you handing over without taking the permission of the court? Keep it in your hand. We may not allow. Yes. Who dismissed for default? Where will hand over? Yes. Hand over.
Lordship, may I permitted to mention, Lordship, motor accident appeal.
Yes. Yes. Yes.
May I have
on-
your lordship kind?
Yes,
May I
Mr.
have your lordship
Chattopadhyay.
kindly? Yes, my lord, I will leave to my lord to appear virtually. One, my lord, civil revision, my lord, was directed, my lord, by last circuit bench, my lord, to appear, my lord, in next circuit bench, this circuit bench, my lord.
Yes.
Only for inclusion, only for inclusion.
Yes. Give the number.
My junior is there, my lord, he is handing over.
Yes. He has done it. Yes.
Grateful to your lordship, grateful to your lordship.
My lord, may I mention, my lord?
Yes, Mr. Sharaf.
My lord, I am praying for inclusion of 3 matters, my lord, ready for hearing, my lord. The affidavits pleadings are complete, my lord.
What matter?
And they are all service tax matters, my lord.
No. Has to be heard by a single judge.
Yes, my lord. Yes.
Do I have determination? We don't know.
My lord, the lordship is taking up any matter as per your
My lord,
lordship.
in item number 21, my lord, I appear for the petitioner, my lord.
My lord. Yes.
Very well, Mr. Sharaf. Yes.
Lord, the
Give the
petitioner
number.
is a FPS
Yes,
dealer, my
my
lord.
junior is there, he will
He
give.
caters business to a certain area, my lord, where a vacancy was.
অন্য কোনো লাইন ইয়ে হয়ে গেছে কি করছে
At any event, my lord, if a license is granted in
নিয়ে নিচ্ছি তো বন্ধ করে দেবে এবার
my lord, it will be
Yes, call on the list. This is the second occasion when none appears for the parties at the time of call, full stop. As a last chance to the petitioner to move the matter, let the same stand adjourned for the day. কালকে point out করে দেবেন, dismiss or default করে দেবো. Yes. Next. Same. Matter has been
Dispose of in the trial court, your lordship. In the civil division is infructuous, your lordship.
Learned counsel for the petitioner submits that the suit. What has been disposed of? The main suit?
No, my lord. Injunction. The senior judge, senior division has granted the interim order, ad interim order, your lordship. The defendant has.
In connection with the misappeal?
Yes, your lordship.
This division is against an order passed in a misappeal?
No, my lord.
Yes, in a misappeal.
Yes, my lord. Misappeal.
The misappeal has been disposed of.
Yes, my lord.
You are challenged the ad interim order?
Yes, your lordship.
Learned counsel for the petitioner submits that the present revision was preferred against an ad interim order passed in a miscellaneous appeal. Since the miscellaneous appeal itself has been disposed of, the matter has been rendered infructuous. Accordingly, CO 141 of 2022 is disposed of as infructuous without any orders to costs.
Grateful, your lordship. Four minutes, Mr. Vikramaditya Ghosh is appearing. He's on his legs, trying to short.
You start. What is the matter?
Because this matter pertains to section 23 of the Senior Citizenship Act panels.
Right. Who are you? You are the senior citizen or the children?
I'm senior citizen.
The petitioner is the senior citizen. Argue their case for him. No. What is the matter about? What have you challenged here?
Our section 23 application was rejected now. That's what I can see.
Have you got a copy of that act, the Senior Citizen Act? At our office, we are passing it over. Let Mr. Ghosh come. Please try to get a copy of the act from the library. আর ইয়েকে আপনি অনেকদিন একটু কাউকে পাঠিয়ে বলে দিন যে লাইব্রেরি থেকে যে সিনিয়র সিটিজেন অ্যাক্ট বললেই হবে। ইয়েস, সিনিয়র সিটিজেন অ্যাক্টটা যেন কোর্টের লাইব্রেরি থেকেও আনিয়ে নেয় আর ওনারা যেন আসছেন। হ্যাঁ, ইয়েস, কলেন। Yes, Mr. Mukherjee.
Lordship, I beg to appear for the petition.
My lord.
Yes.
My lord, I appear for the petitioner.
Right.
Your lordship, on 22nd of August 2020.
Mr. Mukherjee, he is with you. You are with him.
Yes, your lordship.
Yes,
Your
Mr. Mondal,
lordship.
yes.
Yes, my lord, on 22nd of August 2024, my lord, an interim order was granted, my lord, for stay of, my lord, all further proceedings in the title suit, and my lord, I was directed to serve copies. Copies was, my lord, served. Affidavit
Right.
was also filed before this court.
Right. What is the matter about?
My lord, matter was about, my lord, a partition suit was filed, wherein, my lord, I am the defendants.
Right.
Initially, we raised the point that
Give us half a second. Ei board
Yes.
এটা show হচ্ছে না কেন number? হ্যাঁ, board এটা show করো. Yes, please continue.
Yes, my lord, a partition suit was filed, wherein, my lord, I was the defendant. My lord, the plaintiff claims the right under the law of inheritance. My lord, but the point of contention raised by the defendants are that the particular land which the plaintiffs claim partitionable right has already been sold by their predecessors by two registered, my lord, deed of conveyances, one in 1963 and another one in 1964. So, my lord, we took the point that a preliminary issue, my lord, ought to have been framed at the first instance without going into any other issues. And accordingly, my lord, an application under Order 7, Rule 11, read with Order 14, Rule 2 was filed.
Right.
My lord, initially it was rejected. My lord, we approached the Honorable Court. The Honorable Court, by an order dated 24th 11/2023, your lordship will find that at page 64. My lord, allowed, my lord, the civil revisional application, and my lord, the learned trial judge was directed to, my lord, frame the preliminary issue.
Yes.
My lord, preliminary issue was framed, and my lord, that your lordship will find at page 70.
Preliminary issue has been answered now?
Yes, preliminary issue has been answered in favor of the plaintiff. And my lord, the documents were not exhibited even. Without exhibiting the documents, my lord, the preliminary issue has been answered in favor of the plaintiff. So that is the moot point of contention before your lordship as on today. The impugned order, your lordship will get at page, my lord,
Mr. Mondal,
yes, your lordship.
Strictly speaking, an issue has been decided. This should be challenged in the appeal you prefer against the suit.
My lord, kindly seize the order once. Only one thing, my lord, the particular two documents that we are relying upon, my lord, in our point of contention for the maintainability of the, my lord, suit, my lord, the learned trial judge recorded that the documents relied on by the parties are not yet exhibited. So, my lord, without exhibiting the documents, this issue cannot be answered.
Let us just go through the order once.
Yes, my lord.
Let us see the preliminary issue once.
Yes, my lord, preliminary issue your lordship will seize at page, my lord, 70, the earlier page only. Yes.
Right. Please show me the direction of the previous bench of this court.
My lord, that your lordship will find at page 64. 63 it starts, my lord. 63. No, no, 64, 64.
Yes, 67 is the relevant page.
Yes,
so-
yes, 67 is the relevant page.
Yes, right. The defendants in a suit for partition and ancillary reliefs have preferred the present revisional application against an order whereby a preliminary issue was decided, a preliminary issue as to the maintainability of the suit was decided in favor of the plaintiffs. Push up next para. By an order dated November 24, 2023, comma, a learned single judge of this court sitting in Jalpaiguri circuit had disposed of a previous revisional application with a direction upon the trial court to frame a preliminary issue whether the suit is maintainable or not in its present form. Full stop next para. The issue was raised in the context of the present defendants stroke petitioners having raised the issue that the entire suit property, comma, to which the plaintiffs stroke opposite parties claim title, comma, was transferred by them or the predecessor, Mr. Mondal?
My lord, by their predecessors in 1963 and 64.
Transferred by their predecessors in interest in the years 1963 and 1964. Full stop next para. For such purpose, comma, the defendant stroke petitioners also sought to tender such deeds of transfer. Full stop next para. Pursuant to the order of the learned single judge, comma, a preliminary issue was framed on February 23, 2024 to the effect as to whether the suit is maintainable in its present form or not. Push up next para. However, comma, by the impugned order, comma, the learned trial judge proceeded to decide the issue without permitting the registered sale deeds which were furnished by the defendants petitioners in support of their claim of non-maintainability, comma, as evidence or marking the said documents as exhibits. Push up next para. Without marking the documents as exhibits, comma, the learned trial judge acted dehors jurisdiction in deciding the issue in the first place. Push up next para. Secondly, comma, the learned trial judge decided the preliminary issue in an entirely slip-shod fashion, comma, inasmuch as the learned trial judge did not even advert to the deeds produced by the defendant stroke petitioners. Pushed up para. Thirdly, comma, the learned trial judge gave precedence to recording of the plaintiff's name in records of right, comma, which do not confer or create any title, comma, over the title deeds produced by the defendants. Full stop next para. The learned trial judge, comma, surprisingly, comma, held that the documents relied on by the parties are not yet exhibited, comma, but making no endeavor to ensure that such documents were permitted to be marked as exhibits upon being duly proved. Full stop. Next para. That apart, comma, the learned trial judge also observed in the impugned order that without going into the merit of the suit, it would not be proper to come to an adverse finding in respect of a government revenue record or a registered title deed. Full stop. Such logic is apparently, such logic is not tenable in the eye of law. Full stop. The learned trial judge ought to have permitted the defendants to mark the title deeds relied on by them as exhibits and, comma, in the event the plaintiffs wanted to rely on extracts of records of rights, comma, also to permit the plaintiffs to mark such documents as exhibits before proceeding to decide the preliminary issue. Full stop. Hence, the impugned order suffers from material irregularity and palpable illegality. Accordingly, CO number 135 of 2024 is allowed, thereby setting aside order number 22 dated May 18, 2024, passed by the Learned Civil Judge Senior Division at Jalpaiguri in title suit number 6 of 2022, and remanding the matter to the Learned Trial Judge for a fresh adjudication on the preliminary issue already framed by the Learned Trial Judge, after giving an opportunity to the plaintiffs and the defendants to mark the respective documents on which they seek to rely on for the purpose of deciding the preliminary issue as exhibits. Push up next para. Upon such marking of exhibits, the learned trial judge shall give a short opportunity of hearing to both parties and decide the preliminary issue as framed. Full stop. It is expected that in view of the time already elapsed, the learned trial judge shall expedite the entire process and, expectedly, conclude the process of adjudication on the preliminary issue within 3 months from the date of communication of this order to the learned trial judge. So, প্রথমেই একটা করে নেবেন, despite service none appears on behalf of the opposite parties. You have filed the affidavit of service today. Appears for the opposite parties. Accordingly, the matter is taken up for hearing ex parte. তারপর বাকি যেটা করলাম. No order is to cost. What is the can? Can has been disposed of?
Yes, your lordship. My lord, initially there was a can for
disposed of.
extension of the interim order. Yes.
Oh, right. Very. Yes. Thank you.
Deeply obliged, your lordship.
Next. Yes.
Yeah, my lord, the opposite party husband, my lord, filed an matrimonial suit for praying for decree of divorce before the learned.
You were appearing in the first two matters?
Yes, my lord.
Why didn't you appear? We have recorded an order, given you a last chance. 2 consecutive days you have not appeared. 1 and 2.
Lordship was pleased to, my lord, post the matter tomorrow.
I have posted the matter tomorrow, both the matters, but tomorrow is the last chance. If you don't appear, it will be dismissed for default. At least keep somebody, Mr. Mishra. Sorry, please continue with this one.
Lord,
This is appearing at the motion stage or direction given to serve copies? No.
copy has been served.
You are appearing. Yes. What is
the
that?
opposite party husband, my lord, has filed a matrimonial suit praying for decree of divorce on the ground of cruelty.
Right.
Before, my lord, the learned district judge Coach Bihar. Lord, I am the wife. I am residing, my lord, at Coach Bihar. My lord, this revisional application is under section 24 of CPC, my lord, for transfer, my lord, the matrimonial suit from Jalpaiguri to, my lord, Coach Bihar. My lord, the adverse.
Last residence was Jalpaiguri.
Last residence Jalpaiguri, my lord. I relinquished my matrimonial life in the year 2019, my lord.
You reside in Coach Bihar, within Coach
Now
Bihar.
residing in Coach Bihar, my lord. By profession, my lord, I am a school teacher. I have to travel, my lord, more than 40 kilometers, my lord, each and every day from my present residence.
Each and every day of the, you are not required to be present on each and every day. 40 kilometers is not much.
The other hand, my lord.
40 kilometers is too short.
My lord, 40 kilometers from my residence at Coach Bihar, my lord. I am a school teacher. My lord, I have my lord, my child, my lord, who is 3 years old. My lord, he is suffering from, my lord, speech disorder. And my lord, my old aged parents.
Where do you leave the child and parents when you go to work?
My lord, they are at their residence, my lord.
So therefore you can do that for the litigation also. 40 kilometers does not.
Jalpaiguri is almost, my lord, 95 kilometers, my lord, from
No.
Coach Bihar.
What is the distance from the Jalpaiguri court to your residence?
Jalpaiguri court to my present residence, my lord, almost 100 kilometers.
So what about 40 kilometers? 40 kilometers?
40 kilometers, my lord, my lord, my school, my lord, my
Oh,
present,
school is within Coach Bihar.
within Coach Bihar, within the
Achha,
district.
you have to travel 40 kilometers up and down or one side 40 kilometers?
One side.
One side 40 kilometers.
40 kilometers.
So after doing that, you say you cannot travel 100 kilometers to. What does the husband do? School teacher. So she can transfer to the school instead of the suit. Yes, what do you say? 3-year-old child.
I am not able to work. I am now sitting with wheelchair. For that, kindly see page 14. I have stated here.
You have filed an opposition.
No, that is
Page 14, where? Of this application?
15 paragraph 9. in my petition.
Dear my lord, matrimonial suit.
15, paragraph 9. Right, may I read it? So, my lord, 100 kilometers is very difficult to.
You have partially recovered. That partial recovery was, when did you file this suit? In 2024. You had partially recovered at that point of time.
I am dependent on my lord what happened.
Since then, oh, so you have been treated in different hospitals.
But the present.
Present what?
The present adverse situation is that, my lord, my child, my lord, he is suffering from, my lord, a
After marriage,
speech disorder.
See, after marriage, she
Even-
residing, my lord, in
1 minute.
Kuch Bihar.
Yes?
After marriage, she residing in Kuch Bihar. Not a look after my parents and my
No,
lord.
that is a different, that's on the merits of the suit. Can you furnish a current medical certificate?
My lord, page 23, that relates to, my lord, my child's treatment, that regarding, my lord, his speech disorder, my lord.
No, we are not disbelieving the speech disorder.
Yes.
But speech disorder, for that you need not stay at home. I mean, speech disorder, yes, he's being treated.
Round that-
He's being treated. 3-year-old child, speech disorder is curable. It's not so serious. Kotha derite bole is not serious. Many varies from child to child. So, and speech disorder cannot be a ground for you not going to. But see his situation. That is his scenario. I mean, it's an ongoing process. Even in his plaint, he has pleaded para 9.
My lord, the medical certificate he's got from 2023, my lord. Now we are on 25, my lord.
No, we'll direct you to file a medical certificate. File it by tomorrow, by day after tomorrow. The petitioner wife seeks transfer of a matrimonial within bracket divorce bracket close suit filed by the opposite party husband in Jalpaiguri. Push up, the petitioner wife resides in Kuch Bihar and contends that the distance between Kuch Bihar and the Jalpaiguri and the court at Jalpaiguri is about 100 kilometers. Push up, furthermore, the petitioner is a school teacher and has to travel 40 kilometers one way to her school every day. Full stop. Moreover, the petitioner also has a child of about 3 years who is suffering from speech disorder and is undergoing treatment. Full stop. That apart, the petitioner also has her aged parents at home, and it is difficult for her to travel all the way to Jalpaiguri to conduct the suit, to contest the suit. Full stop. Next para. Learned counsel for the petitioner, opposite party husband submits, by placing particular reliance on paragraph number 9 of the plaint of the divorce suit itself, that he is suffering from a serious injury after falling twice. Full stop. Such injury to the right leg and spine has debilitated the opposite party, it is submitted, and his movements are restricted to a wheelchair stroke walker. Full stop. Next para. As such, it is argued that it would not be possible for the opposite party husband to go all the way down to Kuch Bihar and conduct his litigation. Push up next para. In order to ascertain the current position of the physical condition of the opposite party husband, the opposite party husband is directed to file a short affidavit annexing his current medical certificate stroke medical documents to indicate as to the status of his injury at present. Such affidavit shall be filed on July 25, 2025, when the matter shall next be listed under the same heading, with an advance copy of the same to the learned advocate for the petition. Try to obtain it by tomorrow and prepare 1-page affidavit. 7.
I do.
This is the second occasion when none appears for the parties at the time of call. As a last chance to the petitioner to move the matter, the same is adjourned for the day. Next.
Number 8, my lord, I have to effect the service, my lord, once again.
Why not served properly?
My lord, my lord, effect the service earlier, but my lord, the tracking report shows that, my lord, the item was only dispatched. My lord. So whether it was delivered.
When did you serve last?
My lord, it was long back, my lord, in the month of January.
Why didn't you serve again in the meantime?
I will effect the service in the course of the day.
You are enjoying an interim order.
No, man. The order already expired. Lord, I will effect the service in the course of the day, my lord. Kindly.
No, until further order, there is. Serve it immediately.
But I will effect the service in the course of the day, man. Today.
How can you? Where does she reside?
My lord, she resides in the district of Coach Bihar.
Coach Bear, how can you effect so quick? You serve on her as well as her advocate in the court below through your client there or through your counterpart there. Learned counsel for the petitioner submits that the service has not yet been completed with regard to the matter. Whoso, I find from the records that the petitioner is enjoying an interim order, and as such, the matter ought not to be kept pending long. Whoso, at this comma, learned counsel for the petitioner submits in his usual fairness that he will effect fresh service immediately. Whoso, accordingly, the petitioner is directed to serve afresh a copy of the present application on the opposite party directly as well as on the learned advocate appearing for the opposite party in the trial court and file an affidavit of service on the returnable date. The matter shall next be listed under the same heading on July 28, 2025, Monday. Yes, Mr. Rai. Right. This is appearing for the first time, Mr. Yes, what is the matter?
Or whether the shoot on the section on the curb was of conventional right, so it's maintainable or not. This is my issue. The issue of
No, the suit has been filed on the ground that you are a tenant under premises tenancy. No, you have taken a defense that you are a lessee under the Transfer Property Act.
for future. If it is given, what is the judgment?
No, the lease did not expire. Subsisting, continuing. Yes, obviously, if it's governed by the Transfer Property Act, then that. But why should this? I mean, found maintainable. It has been held against you. This could not have been a preliminary issue in the first place. No, that judgment is different. But I mean, what he was saying, I don't remember my judgment, but that is a different proposition. No, if it's a Transfer Property Act governed property, then a notice under that act has to be given. Yes, then the suit. But here their case is that it is governed by the Premises Tenancy Act, which has been upheld by the trial court. Let us see, yes. What is the preliminary issue? Let us see that. Whether the suit is triable under the, yes, that was the issue. Whether triable under 97 Act. So court has found on merits, why should you interfere, Mr.
Can come to case 13. Not base 13. Is a VC. Start from the register is defined.
All right.
It was executed on 15 16 January 1991. It was execute. My lord, your lordship can come to page 18, decide the last one. While in order to avoid all further complication and uncertainty, the lesser have got it available and expedient to have a complete into the registered release. In forwarding, there are all terms and conditions as agreed by to buy and between the time of the tenancy is on the 1st of June 1990. Now your scan come to cross 3 miles at 19. The rate of the premises described the civil bureau and the fixed settle 8,800 per month. 800 per month. That has been taken into consideration by the.
So that has not yet exceeded the statutory limit under. Yes. No, but this can also happen under a registered lease deed under the TP Act also. This by itself does not show it's a monthly tenancy. I mean, premise. Yes.
The regime can have reverted to terminate in that the time of giving the service there on non-notice. So I have a right to terminate it. He has the right to terminate it. So notification clause is not there. The matter 15 is a very, it has not been considered. Then you also can come to how he can enter clause 17 on breach of any of the conditions between you mentioned the research shall be.
We have seen the clause. Let us see how the court dealt with it, Mr. Rai.
Nomenclature does not do anything. The issue has not been dealt with properly. Our point is that when following a lawsuit judgment, if they were given a notice under section 111G.
No, you are given a notice under section 6 of the premises. You are given a notice under section 6 of the Premises Tenancy Act. No, 111G comes only if it's a Transfer Property Act property. But here their plaint case is that it's a premises is governed by the Premises Tenancy and therefore they have given 6.
Issue has not been dealt with properly.
Mr. Rai, this I'll give you liberty to challenge this issue at the final in an appeal against the decree, because this will under 227 it's very difficult for us to go into factual premise. You have not done that.
Issue one main problem.
But
the other side. I have served close and my point is that kind of.
Sir, Rajat Das is appearing means.
My point is that.
No, Mr. Rajat Das has not lodged a caveat.
It is not terminated. The lease is still more than 35 years. And a 56 Act, I am covered. Your lordship has external view, but there is a gray area that will be considered. It's a lease on the lease through the 56 Act. I am more than 35 years in election, but I am enjoying.
Transfer Property Act, have you got a copy of the Transfer Property Act? Just give me a copy. Just give a copy.
They can give a notice on 106 or 111G.
If it's a property governed by the Transfer Property Act.
Section 3 of the Act and governed by law.
An arguable question has been raised by the defendant stroke petitioner inasmuch as whether the jural relationship between the parties is that of tenant hyphen landlord under the West Bengal Premises Tenancy Act 1997 or the predecessor statute, that is the West Bengal Premises Tenancy Act 1956, or as to whether the said relationship is that of a lessor and lessee under the Transfer of Property Act 1882. Who sub next para, learned senior counsel appearing for the petitioner argues that the learned trial judge failed to take into consideration the composite effect of Section 107 of the Transfer of Property Act as well as Section 3 of the West Bengal Premises Tenancy Act 1956, which was prevalent at the juncture when the registered lease agreement was entered into between the parties, in arriving at the finding that the lease is governed by the uh, West Bengal Premises Tenancy Act 1997. For sub next para, this revisional application is required to be heard on the above question. So accordingly, the petitioner shall serve a copy of the revisional application on the opposite party, indicating that the same shall be listed before the next circuit, before the appropriate bench of the next circuit, subject to being mentioned before the said bench. Full stop, there shall be stay of all further proceedings in title suit, in OC within bracket eviction, bracket close, suit number 199 of 2022, pending before the learned civil judge junior division at Siliguri district, Darjeeling, till September 30, 2025 or until further order, whichever is earlier. বইটা ফেরত দিয়ে দেবেন।
Mention they mentioned that the division with
Pardon?
The division bench, Mr. Sudhipto Majumdar, you also fix the matter tomorrow.
Yes.
He said that he mentioned.
He has mentioned, I said that let it appear in the list and then if somebody will. You are for the other side. Yes, we told him to inform you. Yes, Mr. Sengane, what is this?
Case, I have challenged the order passed by the arbitrator.
Appearing for the first time.
First time.
Arbitrator.
Yes, since that there is very limited scope and this order is applicable one as per the section or impugned order. It's admitted. But your
What is the order under?
Exceptional case because your lord.
No, order is under which provision? Impugned order?
Section 17 your lordship.
Ah.
See, this is the exceptional case. I filed within 1 month as because your
No
lordship.
exception, section 5 of the Arbitration and Conciliation Act diverts the court from judicial intervention.
But limited scope if the patently perverse, if the arbitrator, lordship.
Patent perversity is covered by section 37.
I appreciate this point. Lordship, in this proceeding, your lordship, landed arbitrator pass an order, interim order, quoting section 117, your lordships. In another proceeding, pass an order related.
Quoting
to
section 117 of?
17 of Arbitration and Conciliation Act says there is.
No, quoting section 17.
17 Arbitration Act.
Yes.
Lordship, the fact is.
No, what order has been passed? Injunction.
Lordship, in the development proceeding, your lordship, stay the development proceeding. This is a separate proceeding. This is not the reference made by the court, your lordship.
This ground is available in section 37 also.
37(2) is there, your lordship. But your lordship, kindly appreciate my facts. It is the exceptional case. Lordship, kindly appreciate.
There is no exception. Section 5 is very clear. There is a specific section in the Arbitration and Conciliation Act, section 5, which prevent judicial intervention.
Lordship, but our Supreme Court, several judgments is there. 227 is the judicial review power, your lordships. Even if the sumoto, lordship, kindly appreciate the facts at first.
How can we look into the facts in 227?
Right, there's a totally law point, your lordship. Not in the
what is law point?
Lordship, in this case, your lordship, respondent is a licensee. Now there is a defaulter licensee. Now in the Airport Authorities Act 1994, there is a provision for first termination proceeding. It is a separate proceeding. Now after the termination proceeding, the question comes for recovery of dues. Now there is a section 28G says, your lordship, one prescribed officer is termed as eviction officer, pass an order for 28G. Now against the order of the 28G, the licensee has the entitled to prefer and the appeal before the Honorable High Court. Earlier 22, there is a tribunal. Now here in this case, your lordship, termination proceeding is over. Now 28G erection officer passed the 28G order. Now after the 28G order, licensee not prefer any appeal or challenge the order. Now airport authority filed the execution before the civil judge senior division as a money decree. Now in the meantime, the licensee file an application seeking some compensation on the several grounds. Now the airport authority denied. Subsequently, they filed a section 11 applications before the honorable court for appointment and arbitrator. Now, honorable court appoint an arbitrator, and your lordship for resolve the dispute on the basis of this application filed by the licensee. Now, subsequently, there is the provision for in the award and the license, the debarment proceeding. If you are a defaulter, if you are not paying the rate, not 2 or 3 years, the license is not entitled to for future contract, entitled future.
You say regarding the eviction proceeding, the scope of the arbitration was the eviction proceeding.
No, your
The rent, recovery of rent.
No, lordship. Arbitration proceeding only relating to the PT application filed by the licensee regarding the compensation. This is a separate one.
But while deciding that, the arbitrator has
Pass another debarment proceeding.
that may be a patent perversity, but 227 code.
Patent perversity. If I am lordship, why I am not filed the 37.2? Lordship, if I am filed the 30 appeal, your lordship,
Yes.
and the arbitration proceeding is stayed, but the total arbitration
Why
consideration.
should the arbitration proceeding be stayed automatically? You can file a 37 appeal. File a 37 appeal. That's the remedy. The court can grant a stay of operation of the order, refuse to grant anything.
Limited scope as because your lordship, the arbitration proceeding is going on. And 227 has the power to the judicial review, your lordships also.
No,
Your
sorry.
lordship, in
The-
this case, I have, lordship, I have filed the within 1 month this petition. And 37 limitation is 3 months. Within 1 month, I prefer the 227, your lordship.
No difficulty in that, but no.
Because-
You still have time. You still have time. We will give you.
Things totally perverse, your lordship, patently perverse the order.
Learned Counsel, the present application under Article 227 of the Constitution of India has been preferred against an order passed by an arbitrator under Section 17 of the Arbitration and Conciliation Act 1996. Push up next para. Learned Counsel appearing for the petitioner submits that despite the availability of a remedy by way of an appeal under Section 37 of the 1996 Act, the present application has been preferred, seeking judicial review in view of the impugned order being patently perverse. First up, it is contended that while the arbitrator was appointed under Section 11 of the 1996 Act for the specific purpose of deciding a dispute relating to the claim of compensation of the opposite party, while deciding the application under Section 17 of the 1996 Act, a separate departmental proceedings, having no nexus or connection with the arbitration clause or the arbitral proceeding has been stayed by the learned arbitrator. First up, it is submitted that the power of judicial review under Article 227 of the Constitution, being a constitutional remedy, adding something, being a constitutional remedy, is not fettered by any piece of legislation. Push up next para. However, this court is unable to accept such contention of the petitioners inasmuch as the maintainability of the present challenge is concerned. Push up. Undoubtedly, the power of judicial review under Article 227 is under normal circumstances not circumscribed by any legislation, which is subordinate to the Constitution, which empowers the court for judicial review. Push up. However, the question is as to whether this court should exercise its discretion in the circumstances of the present case to invoke such supervisory power despite a specific remedy being prescribed under the concerned statute. Push up next para. The bar, the illegality stroke perversity complained of by the petitioners is of such a nature which is amenable to the alternative remedy of an appeal under Section 37 of the 1996 Act. Full stop. A special feature of the 1996 Act is Section 5 of the same, which, comma, in specific terms and by providing a separate section, comma, restricts judicial intervention apart from those cases where such intervention has been specifically provided for under the statute. Full stop. The entire scheme and object of the 1996 Act is to promote India as an international hub of alternative dispute resolution, comma, as declared in its statement of objects and reasons itself. Full stop. Next para. It has been consistently held by judicial opinion, both by the Supreme Court as well as different high courts of the country, that the least interference in arbitral proceedings, comma, the better. Full stop. Next para. As such, comma, since the issues raised in the present application can also be canvassed in a proper appeal under Section 37 of the 1996 Act, which provides an equally efficacious alternative remedy, comma, this court chooses not to exercise its jurisdiction under Article 227 of the Constitution of India, but to relegate the petitioners to the appropriate appellate forum. Full stop. Accordingly, CO 88 of 2025 is disposed of by granting liberty to the petitioners to challenge the order impugned herein by way of a proper appeal under Section 37 of the Arbitration and Conciliation Act 1996. Full stop. For such purpose, comma, the learned advocate on record for the petitioners is granted leave to take back the certified copy of the impugned order upon furnishing a photocopy of the same for the records. No order is to cost. It is made amply clear that this court has not touched or entered into the merits of the contentions of the parties at all.
Lordship, one liberty. During the period, the pendency of the period, the limitation, otherwise the limitation is going to.
Your limitation is still there. When was the order passed? 14/2/2025.
Lordship, already.
3, 4.
We have filed within 14th February, 3-month limitation.
No, there is a provision of condonation of delay before that was there. So you can also plead Section 14.
Within the period, filing.
You have to apply there. For condonation of delay, one you can, and you can also plead Section 14 of the limitation. How can I, if I don't have jurisdiction? Mr. Singhane, go there and apply. You know what provisions. 5 as well as 14. Yes. Yes.
Lordship, in item number 11, I am appearing on behalf of the appellate petitioner. Would be grateful if Lordship kindly fix the matter tomorrow.
No, I cannot make you grateful. This is the third occasion. By the previous order, it was recorded. Second occasion, none appears. Last chance to the petitioner to appear and move the matter. If you don't move today, gets dismissed.
My lord, the conducting counsel will be coming in person tomorrow.
No, maybe. You are there. What is the matter about?
My lord, I have been instructed.
Prepare yourself. Eta diye din. We'll give a short passover. Prepare yourself and move the matter. সবকটা পাসওয়ার্ড একসঙ্গে ডাকবো এখন আপাতত দিন গেট রেডি ইন দ্য ম্যাটার যখন পাসওয়ার্ড ডাকবেন যে পাসওয়ার্ড যে অর্ডার হয়েছে সেই অর্ডার ডাকবেন এখন পড়ো গল্প Please.
I am for the defendant. May it please your lordship.
Defendant means you are not for the petitioners.
Milani brothers, I'm for them. The petition.
Milani brothers are the petitioners, yes.
Yes. May it please your lordship, I humbly submit before you that my learned counsel is in the presently occupied in courtroom number 4.
Passover, let him come. Passover thak.
Your lordship.
This is the third Passover holo.
So, my lord, I am for the petitioner.
I never knew you were a doctor. Sorry, I have called you Mr.
August.
Oh, recently. Good to know that. Congratulations. And what is your matter?
Matter, my lord, it's under the Forest Act. Now, my lord, in brief, I'll place the facts first.
This is the first instance you will. Yes, in brief.
My lord, this petitioner's vehicle, my lord, was apprehended by the Forest Department
Hmm.
with logs, teak logs. Milord, thereafter seized, it was seized and sent to the authorized officer who is the Milord DFO of the concerned division to confiscate the vehicle as well as the tick logs. Now, my lord, once the confiscation proceeding started, my lord, notices were served to the petitioner who is the owner of the vehicle. My lord, he appeared before the DFO. My lord, he was asked to give his statement on oath. On oath, he has given his written depositions, and on the basis of that, as well as the statements of the forest department officials who had apprehended the vehicle, my lord, it was finally confiscated. My lord, challenging that order, my lord, we have preferred a statutory appeal before the learned district judge. The district judge also, my lord, turned down our appeal. And my lord, now we are before your lordship, my lord, under 227, challenging the confiscation proceedings by the DFO as well as the impugned order.
Scope of interference under 227 is limited.
It's a settled law now, my lord.
No, limited. I'm
Yes,
saying
it's
limited. It has to be something jurisdictional or what is that?
Of law, my lord, on two important questions of law, my lord, I have filed this application. First is, my lord, the DFO, my lord, cannot go with the confiscation proceedings unless there is a forest offense. Now, my lord, unless there is a forest offense. My lord, forest offense is a sine qua non to confiscate any property.
No, this is not a forest offense.
My lord, no separate criminal proceedings has been instituted.
Achha, under the Forest Act.
Under the Forest Act. Lord, that is the sine qua non.
So there is no forest offense disclosed in the FIR.
No.
All
no
right.
FIR has been lodged. In fact.
Oh, no FIR.
No FIR has been lodged.
Achha, second ground.
Second ground is, my lord, this petitioner, my lord, was only granted, my lord, an opportunity to place his version, place his deposition, but my lord, he was not granted any opportunity to cross-examine the prosecution witnesses, which is, my lord, a blatant violation of the principle of natural justice.
What sort of interim order are you expecting? No.
My lord, no scope of interim order.
Serve copy and come back. The petitioner has raised certain salient questions in the present challenge, preferred against an order of confirmation whereby the vehicle of the petitioner has been confiscated by the DFO under the Indian Forest Act. Full stop. Next para, learned counsel appearing for the petitioner contends that in the absence of any FIR being registered in respect of any forest offense having been committed by the concerned vehicle, comma, no, the DFO did not have any jurisdiction to confiscate the same. Push up, it is argued that a forest offense is a sine qua non for to clothe the DFO with jurisdiction. Push up, next para. Secondly, comma, learned counsel submits that although opportunity of what was the opportunity given to you?
Place his version, my lord.
To place his version was given to the petitioner, comma, no specific opportunity to cross-examine the witness. The witnesses was afforded to the petitioner, comma, which according to the petitioner, comma, vitiates the confiscation process itself. Full stop. The present revision is required to be heard on the above questions and the other grounds taken in the application. Full stop. Accordingly, the petitioner shall serve copies of CO 98 of 2025 on the respondents, on the opposite parties, indicating that the matter shall be listed before the appropriate bench in the next circuit, subject to being mentioned by the parties. Full stop. The petitioner shall file an affidavit of service on the returnable date.
Next week, if it is possible, only upon the state it has to be.
Next week, you can, very well. তাহলে next circuit না করে তাহলে returnable on July 29, 2025, next Tuesday.
Great.
Thank you. Yes. What is it?
13 was rejected but considering its application under section 5. That is the only point to consider.
913 rejection is appealable.
Without considering section 5.
Even then, if your order 913 has been rejected, you have to.
Appealable. Order 913 was rejected without considering the application under section 5 limitation.
Section 5 is rejected here by the impugned order. Miss case and petitioner under section 5. Yes, but since the miscellaneous case itself has been rejected, it's appealable. Prefer an appeal. No, previously that was the position of law, that if section 5 is rejected, miss case is non-est in the eye of law, Therefore, Section 5 is challenged in revision. Consistent view of Calcutta High Court, now changed by the Supreme Court. In several judges, now it needs settled.
May I come to the
No. You cannot come to the main point because revisional application is not maintainable.
army officer, he is a brilliant army officer. She stood first and gold medalist from Chandigarh University in electronics communication.
Kudos to
And
her.
fortunately,
Kudos to her, but you prefer an appeal.
she was in Sukla and she
No,
got
no,
tapped by this gentleman. This went on ultimately, my lord.
No, if we have full sympathies, but your appeal is, you have to prefer an appeal. The present challenge has been preferred under Article 227 of the Constitution of India against an order whereby an application under Order 9 Rule 13 has been dismissed consequentially upon the connected application for condonation of delay being rejected. Push up next para. Since the impugned order is appealable under Order 43 of the Code of Civil Procedure and the provision of appeal provides an equally efficacious alternative remedy, this court is not inclined to entertain the present revisional application. Push up accordingly. CO 104 of 2025 is disposed of by granting liberty to the petitioner to challenge the impugned order by way of a properly constituted appeal before the appropriate court. Full stop. Leave is granted to the learned advocate on record for the petitioner to take back the certified copy of the impugned order upon furnishing a photocopy of the same for the records. It is made clear that the merits of the contentions of the parties have not been gone into, no others to cost. Limitation, as I told the previous person, you have to prefer before that court. Ask before that.
Well, because the order was filed on 28 November.
Limitation, you have to file a Section 5 application before the appellate court, and you can invoke Section 14 if you can. Section 14 should not be applicable. It's now well settled that it's appealable. Section 5, yes. That for that liberty is not required. I've given you liberty to file an appeal. Yes. Next. Yes. Yes, Mr. Shah.
Petitioner. The petitioner wife has paid for transfer of matrimonial suit from the district of Coachbihar to Alipurduar.
What is the distance?
Distance is 22 kilometers. This is not the distance issue. The issue is this: the petitioner has been facing some oppressive atmosphere, and there is a specific incident also that has been reported in the local police station in the Sodor of Coachbihar district itself, with the Kotwali police station. And not only that, the strenuous relationship was going on for a couple of years. The series of litigation is also pending. That one of the litigation is still pending with in the district of Alipurduar. However, since the petitioner has facing some.
What is the pending Alipurduar?
Alipurduar, one proceeding.
125.
No.
Return of
vehicle, return of season article was.
Yes, filed.
Yes. Now the petitioner is also a government employee. He is a teacher.
When did you file? You say you are facing some, what sort of oppressive?
The specific GD, that is page 55 of my application, and subsequent also. Okay. Page 55.
They reside in Coachbihar.
Husband.
Yes, what do you say?
The allegations made by them, my lord, are
Obvious.
absolutely vague, my lord. Now, my lord, why do I say so? My lord,
Is there any child of the marriage?
no, my lord, no child.
Yes, please continue. Yes.
My lord, the marriage, the present proceedings, my lord, was filed in the month of my lord, 21/3/2023, my lord. My lord shall find that from
21/3/23, yes.
the
What is the stage of the suit?
But
Evidence is going.
Evidence is going on. But subsequent to that, my lord, the wife, the petitioner herein, my lord, files a criminal complaint under section 498A. Subsequent to that, my lord, 406, 409, and 322.
against the present petitioner and her in-laws. My lord, the in-laws come up before this honorable court for quashing of the proceedings, and the distant in-laws, my lord, their proceedings have been quashed.
Distant ones have been quashed,
Distant
but
has
not
been-
the close one.
Not now, my lord, after that incident, my lord, they go to the, my lord, the PS, which the document, my lord, they are relying upon, my lord, page 55.
Yes.
My lord, they go to the PS and they lodge this complaint, my lord. My lord, the date of complaint is, my lord, 14/4/2025. And my lord, kindly takes the second last page of the internal the internal certified copy, my lord. Second last page of the application, my lord. My lord has found it.
Say, what is the date?
The date is, my lord, 10/5/2025.
Yes.
Today is fixed for evidence. But had it there been oppression upon the opposite party, upon the petitioner wife, my lord, she could have easily brought this before the knowledge of the learned district judge, my lord. Why didn't she choose to do so, my lord? My lord, the mayor's intention, my lord,
Let him complete. Let him complete.
the mere intention of the wife, my lord, is to harass the petitioner, my lord, in every way possible, my lord. This has been going on since long. My lord, the petitioner comes up before this, the petitioner files a matrimonial suit, my lord, on the ground of desertion. My lord, they file a counter.
No, this transfer is what suit is being sought to be transferred?
Matrimonial suit, which have been instituted by me.
You have filed a divorce suit.
Yes, my lord.
They have also filed a counter divorce suit.
No, my lord.
You have filed.
My lord, I have filed.
Please have further.
My learned friend is.
Wait. Order number 15 is dated 7th of February, when the next date was fixed on 10th of April.
10th of April.
10th of
The next order is 10th of May. Or is it an erroneous recording? What happened on 10th of April?
Yes.
What happened in between? You have, because your allegation is based on 10th/4, this attack on you.
Yes.
10th/4, we don't find any date of the suit also. I mean, it was fixed for further evidence. Maybe that 10/4 has been erroneously recorded as 10/5.
I have to take instruction on that particular because I cannot.
You have to add something. We'll complete you then.
No.
Yes, he's right. You should have pointed out. You would have pointed out before the court itself.
Is that this is the post-session occurrence outside the court premises. That is the in the court building, court compound. That was not. There was no occasion to report all these things to the court, to the particular court concerned on that particular day. That's why it has been subsequently lodged in the local police station. Not only that, that subsequent incident that has also been reported in another police station also, where the petitioners originally resides at.
But if they can do it in Coach Behar, they can come across 24 kilometers and do the same thing.
Kilometer is not the issue, Lordship.
No, they can come to Alipurduar court also and do the same thing.
No, because why I'm telling
The distance is not much. That is what we are saying.
No,
I mean, you are at similar risk in Alipurduar court also.
No, there is.
You seek police protection from the court.
Since Lordship, I am.
We can grant you leave to apply for police protection before the court.
Yes, according to the statutory scheme, there is a scheme also that witness protection scheme also. I have heard it. I have taken the plea also that in paragraph.
Witness protection in civil matters.
No, yes, because section 128 of the Indian Evidence Act, 118 to 100.
So you have resort to that.
No, I didn't resort at
do that.
No, so my humble submission, another more ground is that
this is not substantiated. Moreover, it transpires that you did not point out anything.
No, I could not, there was no occasion to report.
No,
all
before
these things
14th
before the
also
court.
there were no allegations before 14th. 14th was the first time when this happened. 14-4.
No, there was not so serious matter earlier because there was a persisting, because on the backdrop of the attempt of Salisi, when the Salisi could not succeed, then this suit was filed. And not only this, subsequently all this was continuing.
See, one question is coming to our mind. If this happened on 10th of April 2024,
Yes.
2025, you lost the complaint with the Kuch Bihar police station itself.
Yes.
Now, why didn't you lodge the complaint on the same day? You came back on a different date when it was not even a date for the suit, just to lodge the complaint 4 days after. Because at page 55 in your complaint, the complaint is dated 14th of
14th of
April.
April.
You complain of an event which occurred on 10th of April.
10th of April, yes.
And on 10th of April, on the same date, you had already lodged a complaint with the women police station regarding your probably under 498A. I mean, it appears so. So,
On that
what prevented you from you went to the police station on 10th April itself,
Yes,
and you did not complain of this, and you waited for 4 days to come back to that same place of occurrence and complain.
Difficulty was that also the petitioner is an employee. He is a school teacher. He was
On 10th April itself, you lodged a complaint with the police. And on that date itself, this happened.
Yes.
And you, without any complaint, you went back home and came back on 14th, which was not a date of the suit.
No.
What no?
Yes, exactly. There was on the
Yes, no, but not very good.
I'm saying that on that particular.
No,
case,
not does not appears to be for the purpose of embellishing your criminal case.
that
Will not say that, but that probability cannot be ruled out here, Mr. Das. This is not a sufficient ground for anybody that then can have a transfer.
School teacher, there is a draft of teachers faculty in the school. The petitioner himself herself has to take multiple classes.
That will not make a difference if you either go to the Kuch Bihar court or the Alipurduar court.
Alipur was a convenient one.
You're also a school teacher. 50-50.
This staff of the particular college.
He has to attend more than you. He's more at risk. If he's a group D staff and you are a teacher, he's more at risk of retrenchment. Yes.
Kindly appreciate this thing, Lordship.
No.
Kindly
No transfer on this ground, Mr. Das.
The distance is not the issue, Lordship. The petitioner.
Distance is not the issue. We understand.
Lordship, what is falling from your Lordship, that on that particular date, that should I take up specific instruction that particular when the date.
No question of instruction. It is evident from the records.
Order number 15 is not clear at all, because there was a date on.
No.
One day.
No. After hearing is over, no. The present application has been filed under Section 24 of the Code of Civil Procedure for transfer of a divorce suit filed by the opposite party husband against the petitioner wife in a court in the
District Judge,
it's before district judge himself. Before the learned district judge, Kuch Bihar. Puts up, learned counsel for the petitioner submits that the petitioner is a resident of Alipurduar. Puts up, although the distance between the two places is merely 24 kilometers, the petitioner, it is contended, apprehends serious risk of life and limb, since the petitioner is being threatened on every occasion when she goes to attend the suit, by the opposite party husband and his family members and henchmen. Push up next para, learned counsel places particular reliance on several complaints lodged by the petitioner before the concerned police station, that is the women police station, Shodor, Kotwali, Kuch Bihar. Push up in particular, learned counsel for the petitioner relies on a complaint dated April 14, 2025, where it was made out by the petitioner that on April 10, 2025, which was a date for hearing of the suit, the petitioner was seriously threatened of dire consequences by the opposite party husband and his relatives unless the petitioner withdraws proceeding under section 498 capital A stroke 406 of the Indian Penal Code. Full stop. Next para. It is further submitted that in view of such three serious threats, comma, which is also borne out by subsequent applications and complaints made by the petitioner as annexed to the present application, comma, the petitioner would be jeopardized if she has to contest the litigation in the court of the district judge at Kuch Bihar. And as such, the suit may be transferred to any court, any competent court at Alipurduar. For the next para, learned counsel for the opposite party husband submits that on the date itself, comma, if the petitioner was threatened stroke assaulted, comma, that is on April 10, 2025, comma, which was admittedly a date of hearing of the suit, comma, the petitioner could have pointed out such alleged threats to the learned district judge for appropriate remedial measures being taken. However, comma, it transpires from the order of that date, within bracket, erroneously, apparently mentioned erroneously as double inverted with the 10 stroke 05 stroke 2025, double inverted close, bracket close, comma, it will be evident that the PW1 was cross-examined on behalf of the defendant stroke present petitioner. Full stop. There is no reflection whatsoever in the said order as to any such complaint being lodged by the petitioner before the court of the district judge seeking protection or complaining of the harassment she was allegedly suffering. So next parallel, counsel for the opposite party further adds that the petitioner has been consistently making false complaints against the opposite party husband and his family and has lodged several criminal cases. Full stop. One of the criminal cases lodged against distant relatives of the opposite party has since been quashed, comma, although the other cases against the opposite party and his immediate family members are still pending. Full stop. Thus, comma, it is submitted that the allegations made in the present application ought not to be believed. Full stop. Next para. Upon a careful consideration of the annexures to the present application, comma, it is seen that apparently the order dated April 10, 2025 has been erroneously mentioned in the order sheet as May 10, 2025, comma, which is also evident from the serial numbers of the said orders, full stop, whereas order number 15 was dated February 7, 2025, and on the same date, comma, April 10, 2025 was fixed as the next date, comma, order number 16, comma, that is the very next order, is recorded in the certified copy of the order sheet as May 10, 2025. Full stop. Since there was no date in between and there is no reflection that the matter was not taken up on April 10, 2025, comma, this court comes to the conclusion that order number 16 was actually dated April 10, 2025. Full stop. As rightly pointed out by learned counsel for the opposite party, comma, there is no semblance of a mention regarding the alleged harassment suffered by the petitioner in the hands of her in-laws on the said date. Full stop. However, comma, the benefit of doubt in that regard may be extended to the petitioner inasmuch as it is not clear from her complaint dated April 14, 2025 as to when the alleged threats took place, comma, whether while going to court or when returning. Full stop. Be that as it may, comma, it also transpires, it also seems to beg credibility, beg credibility, that the petitioner, comma, who had lodged a complaint on different allegations before the women's police station at Shodor, Kotwali, Kuch Bihar on the self-same date, that is on April 10, 2023 itself, comma, the petitioner forgot to or did not lodge a complaint before the self-same police station about the alleged harassment suffered by the petitioner in the hands of the opposite party and his relatives. Full stop. It is also surprising that instead of adding the complaint of such harassment with the other complaints lodged by her on April 10, 2023 itself in a police station at Coach Bihar, the petitioner merrily came back to her residence and returned to Coach Bihar on April 14, 2025, which was not even a date fixed for hearing of the suit, just to lodge a separate complaint regarding the alleged harassment of April 10, 2023 before the Coach Bihar police station. First up, such chronology of events does not inspire confidence in the allegations made against the opposite party by the petitioner. First up, that apart, this court cannot entirely rule out the possibility of the present allegations being in support of and to strengthen the cause of the petitioner in the criminal cases. First up, however, nothing in the above observations should be deemed to be conclusive insofar as the conduct of the petitioner or the veracity of the complaints are concerned. Full stop. However, in a proceeding under section 24 of the Code of Civil Procedure, it is the balance of probabilities which has preponderance of probabilities which has to be looked into. Full stop. On such yardstick, this court does not find the allegations made in the present application to be so credible so as to transfer the suit from Kuch Bihar to Alipurduar. Full stop. In any event, in view of the nature of the allegations sought to be leveled regarding threats being issued by the opposite party, if the opposite party and his family were so hell-bent upon threatening the petitioner, the same conduct can be done while the petitioner goes to the court at Alipurduar as well, since admittedly, the distance between Alipurduar and Kuch Bihar is about 24 kilometers. Full stop. Next para. In view of the above, I do not find any substance in the present application for transfer. Full stop. Accordingly, CO 115 of 2025 is dismissed on contest without any orders to cost. Thank you. Thank you. Next.
My
16
lordship, I am the
16 পড়ে না
petitioner in person.
অনেক পাসওয়ার্ড ম্যাটারগুলোটা Yes, sorry. Yes.
My lordship, I am petitioner in person in this matter, item number 16, my lordship.
Yes, what is the matter? Move your matter.
My lordship.
Move your matter. Argue
Yes,
your
my
matter.
lordship, my lordship. This is a civil division matter, my lordship. Here I am the petition number 2. Petition number 1 is my father, my lord.
Yes. What have you
Order dated
challenged?
20th June 2000. My lordship, I challenge that an execution proceeding is going on of the decree which has been decreed in favor of my father, my lordship. The decree is about of permanent injunction and declaration, and civil court passed the decree and permanent injunction on 8th December 2011. That decree is going to be executed under order 21 and rule 32 CPC, my lordship. And in the execution proceeding, when process server has come to deliver the possession to the decree holder, they can't deliver the possession for the obstruction of the respondent. Here, private respondents, my lordship, who is the judgment debtors of that decree. And after that, police help has been sought before the court under order 21 rule 97, and also the writ of delivery of possession has been issued under order 21 rule 32, my lordship.
Right.
32 CPC, my lordship. My lordship, civil court has been has allowed this prayer of order 21 rule 97 after contest of the said miss case, my lordship. That miss case has been numbered as 7 of 2025, but here an order has been made in the ordered portion, my lordship, that is in page number 64, my lordship. My lordship, my lordship, second line of the ordered portion,
You
my
have
lordship.
stated, you have given the date of the order 28th June, but in the certified copy it's written 20th June. Probably that's also a mistake.
Yes, yes, my lordship, my lordship. Maybe that
Anyway,
is my
let us
one
come to
point.
page 64. Let us come to that. Yes. What was your
My
argument? Yes.
lordship, yes, my lordship. In the page number 64, second line, my lordship.
Yes.
Civil court has ordered that the additional SP Alipurduar is required to provide the estimate cost which shall be bear by the decree holder regarding police help and
Yes. What is your grievance?
requirement of the
What
police personnel.
What is your objection?
My
What is your
lordship,
objection?
I am. My
Yes.
lordship, my objection is this cost must be bear by the judgment debtor either or by the state respondent. My lordship, state respondent, I am referring to SP and IC whether I have a order of civil order. I have a order passed in my lordship page number, my lordship 21, my lordship page number 21. The order has been passed upon the SP and IC, my lordship. My lordship, item page number 21, my lordship.
Yes. This was in a writ petition.
Yes, my lordship. This writ petition,
This was in a
directs
different
the
context. But in an execution case, why shouldn't you bear your own expenses? Because it's a private dispute. It's not something of a public nature, not a public disorder. It's a private decree which you are wanting to implement. So why shouldn't you bear the cost? You are the decree holder.
yes, my lordship. However, in this writ, it is ordered that, however, the state respondents are directed to ensure strict compliance of the direction of the learned trial court passed in judgment on 8 December 2011 in
Oh, acha. Oh, this
connection of
order was
suit
passed.
number 11
This order was passed in respect
earlier,
of
my
the
lord.
same degree.
Yes,
Acha, acha.
yes, my lord.
Oh,
Yes,
acha.
my lord.
You say
That's
this
why
is
I am
contrary to that. Contrary to that.
Yes, yes, my lordship. It's same decree, my lordship, same order, and this decree has been executed, my lordship.
But
And according to
expertise.
order 21, rule 32, my lordship, judgment debtors are liable to bear the cost, my lordship, as their punishment, because this is the decree of permanent injunction where they
Miss
can't
Bonik, you are right.
enter.
You are right. But there, if they don't do it, then you have to first bear the cost, and then that can be recovered from the judgment debtor as a part of the decree.
Yes, my lord.
First of all,
I
you
am
have to bear the cost.
saying that, and my lordship, this did not also do.
But then you have to serve copy on the
My
other
lordship?
side. You have already served a copy of this revision on the other side. This is appearing for the first time. কেটে যাচ্ছে ওর ইয়েটা। The petitioner number 2 appearing in person contents that
My lordship.
yes, we are. I am admitting the revision. I am directing you to serve copy on the other
My
side.
lordship, my lordship.
A very good argument, Ms. Bonik. Are you a school student or a college student or what?
My lordship, college student. My college has been completed in last year, my lordship.
Very good. You look like a school student though. Yes, very good argument. The petitioner number 2 appearing in person contents that the petitioner stroke decree holders obtained a decree of declaration and permanent injunction on December 8, 2011. Subsequently, upon violation of the said decree by the judgment debtor stroke opposite parties, comma, execution was levied, and in connection therewith, comma, by the order impugned herein, comma, an application for police help filed by the present petitioner was allowed. However, comma, the grievance of the petitioners is that while so directing, comma, the learned executing court observed that the costs for police help should be borne by the decree holders petitioners. Learned counts the second petitioner appearing in person, comma, submits that the said direction is contrary to an order dated June 14, 2022, passed by a by a coordinate bench of this court in WPA 174 of 2022, where it was specifically directed that the state respondents shall ensure strict compliance of the direction of the learned trial judge passed on December 8, 2011 in title suit number 112 of 2010. Full stop. Moreover, comma, it is contended that it is the judgment debtors who should bear the expenses. Full stop. Next para, this revisional application is required to be heard on the above questions. Full stop. Accordingly, the petitioners shall serve copies of the revisional application on the opposite parties, indicating how soon can you serve, Ms. Bonik?
My lordship, I want to do this matter in this circuit. Maybe this matter fixed before the next week, my lordship.
Indicating that the matter shall next be listed on July 30, 2025. Full stop. An affidavit of service shall be filed on the next day. Full stop. Such service shall be effected directly on the opposite parties and/or the advocate on record appearing for the opposite parties in the executing court. So you serve both on the opposite parties themselves and their advocate appearing in the executing court.
Yeah, okay, my
Either
lordship.
will do, because that will make it easier for you to, otherwise it won't be served within this period.
1 minute.
Very.
My lordship, this matter has been next
30,
date, my lordship.
30th of July, 30th, 29th or 30th?
My
30th of July.
lordship, can be it placed on next Monday or Tuesday, my lordship.
Tuesday will be able to serve. Very well. Next Tuesday then, July 29th. Then.
Tuesday.
29th.
My lordship, next Tuesday.
Next
My
Tuesday, yes.
lordship. Grateful, my lordship.
Thank you. Pass forward. देखिए फाइल yes, Mr. Ghosh.
Doctor was opposing me.
Yes.
This is against Millard and appellate order Millard under the Senior Citizens Act.
Oh, yes, that. I requested you to bring the book. Thank you. Yes.
Yes,
Senior Citizen Act. You are the senior citizen. You are the father. What has been done?
kindly text Millard the impugned order.
Yes.
Appellant so-and-so, respondent so-and-so both appeared in person before the appellate tribunal for hearing the appeal petition and filed their respective ajira. I heard both the parties peruse the appeal petition and relevant documents, reviewed it carefully and satisfied that the appeal does not meet the proviso of section 23 of the 2007 Act. Hence, appeal petition is disposed of. Order passed by the learned maintenance tribunal will continue.
What was that order? Maintenance tribunal?
That would take page 52.
But you should have annexed a certified copy of that also. Mr. Anyway, 52. Yes, Mr. Sharkar.
Orders.
Yes.
Effective order is at page 53.
Right.
That is probably 9th October 2023.
Right.
The second paragraph.
Yes.
Considering the fact the OP is directed to give maintenance rupees 3,000 only to the petitioner every month from the month of October so and so. The monthly should be given, monthly maintenance should be given 5th of every month and compliance report should be submitted with 10th of every month. IC Falagata is directed to ensure that the OP2 compliance is submitted.
This was an interim order.
This accordingly submit report accordingly informed to all. But the petition was not disposed of finally.
No, this is an interim order. The petition is still pending. So why did you prefer an appeal?
To the best of my knowledge, the matter has been disposed of.
Subsequently?
No, so by this order. Although it is not written disposed of.
No, for the date has been fixed.
No date is fixed.
The appeal was preferred on the ground that the father was seeking cancellation of the gift deed, which was not.
Obviously, no, if this is the final order, then obviously, I mean, why did you accept the brief?
Actually, there are several other aspects.
Several other aspects. What other aspect? Are these orders?
Filed a suit for cancellation of the deeds.
This is a different statute, different provision. They can do both.
Lordship,
What other aspect?
No, Lordship, to attract section 23, the main ingredients, the basic ingredients are missing in their petition. Section 23.
None of those can be.
No, there is no ingredient. Lordship, kindly consider para 7, page number 49.
Page 49.
Their petition under section 23.
Understood. Page 49. Let us see. Well,
that is the main allegation in para 7 and para 9.
yes, yes. 8, para 8, there is ingredient. Read the second sentence of para 8. The OP prior to.
The opposite, the OP prior to getting the deed promised the petitioner that his wife that he would provide basic amenities.
And basic physical needs. That is sufficient. Need not be put in the deed itself. Need not be there in the deed itself.
But it is not written in the deed.
Need not be. Need not be.
But the
Statute.
But the
Let us
the Honorable Supreme Court in Sudesh Trikara versus Ramti Devi and another.
cite that.
2022 SCC online, Supreme Court 1684.
Give a copy.
I was
Para 12.
anticipating this, so I am also carrying a copy.
This thing.
The para 12.
First, let me just once go through, brush up my memory on section 23. Yes. Para 20?
Para 12.
Para 12. Achha. Yes. Those conditions must be fulfilled, undoubtedly. Where does it say it has to be in the gift deed itself? The statute does not say so. How can the Supreme Court say so? Statute does not say anything like that.
Lordship, if it is not subject to the condition, it must be transferred. But there was no condition in the deed.
That is your version.
No,
He can prove by evidence. He can prove by evidence. Need not be written in the deed itself.
In that case,
In that case, we will allow the revisional application, set aside both, and relegate it to the first forum.
Lordship, it may be, Lordship, my another submission in recent judgment of Honorable Supreme Court in Nasim Kaham and versus although I did not bring that judgment.
Unfortunately, I forgotten to bring my tab here.
Lordship,
So-
this judgment in para 21 and 22.
So that this is the, whatever
It has
judgments have been
it-
last, the position is it has to be conditional. So condition need not
That
be
is the
expressed.
that is section 23 itself.
That is
You read out, please read out para 21 and 22.
It is well settled principle of interpretation that in the interpretation of a deed, the question is not what the parties to the deed may have intended to by entering into that deed, but what is the meaning of the words used in the deed. The court can understand the true intent of the deed only by the words used in the deed. It does not matter what the parties in their most state of mind thought what the terms meant. They may have meaning different things, but still the terms or the language used in the deed should bind them. It is for the court to interpret such terms or language used in the deed. In Ramgopal versus Nandlal, it is held that in construing a document, the fundamental rule is to ascertain the intention from the words of the deed. The surrounding circumstances are to be considered, but that is only for the purpose of finding out the meaning of the words which have been actually employed in the deed. It would be apposite to refer the following para of
This is not in respect of Senior Citizen Act.
no, Lordship.
Cannot be.
But
What is that reference? SCC online reference? Is it SCC?
2024, volume 7, SCC 245.
I'll deal with that.
So, but the section 23 says, but transfer must be made subject to the condition. But in the
I'll
deed,
deal with this judgment.
in
Yes.
the deed, there is no such condition.
Milord, our division bench judgment, Shohidun Nisa, Milord would.
No, we'll interpret the Supreme Court judgment and this. The present challenge has been preferred by the father of the opposite party against an order whereby the appellate forum under the Maintenance and Welfare of Parents and Senior Citizens Act 2007 dismissed an appeal preferred against an order of the first forum whereby the first forum is the SDO.
SDO.
First forum, that is the subdivisional officer, comma, instead of cancelling the gift deed executed by the purportedly executed by the petitioner in favor of the opposite party, comma, granted a meager amount of maintenance. Full stop. Next para. Learned counsel for the petitioner submits that neither the appellate tribunal's order nor the order of the SDO are backed by reasons, full stop, without granting any opportunity to adduce evidence or interpreting the deed in appropriate manner, comma, proceeded to decide the matters. Full stop. As such, comma, the impugned orders being not sustainable in law and devoid of reasons, comma, ought to be set aside. Full stop. Learned counsel places reliance on the language of section 23 of the 2007 Act in support of his contentions. Full stop. Next para. Learned counsel appearing for the opposite party's son submits that the basic ingredients of section 23 of the 2007 Act are missing from the pleadings, that is the application made under the said provision by the petitioner in the before the SDO. Secondly, comma, the deed itself does not contain any provision that it would be incumbent on the opposite party, comma, as a prerequisite of such transfer, comma, to provide amenities and physical needs to the petitioner. Full stop. Next para. Learned counsel seeks to rely on the judgment of such and such reported at 2022 SCC online SC 1684, as well as the judgment of such and such reported at 2024 7 SCC 245 in support of his propositions. Full stop. Next para. Upon going through the materials before the court, comma, it is seen that the impugned order of the appellate authority is palpably vitiated by lack of reasons. Full stop. In an utterly casual and cursory manner, comma, the appellate tribunal observed that it had perused the appeal petition and relevant documents to give deed carefully and was satisfied that the appeal does not meet the proviso of section 23 of the 2007 Act. Full stop. Next para. The SDO, comma, by the order which was challenged by the petitioner in appeal, comma, instead of adverting to the basic ingredients of section 23 of the 2007 Act at all, comma, merely shirked his duty by granting maintenance of a meager amount of rupees 3,000 per month to the petitioner from the month of October 2023. Full stop. Next para. Thus, comma, both the appellate tribunal and the SDO palpably shirked their duty and refused to exercise their jurisdiction under the statute by passing cursory orders without adverting to the merits of the matter and or granting opportunity to the parties to adduce appropriate evidence at all. Full stop. Next para. The premise of the arguments of the opposite party herein is that the ingredients of section 23 were not disclosed in the gift deed itself. Full stop. However, comma, it is nowhere stipulated in section 23 of the 2007 Act that the condition precedent for cancellation of deed must be contained in the concerned gift deed and the said deed alone. Full stop. Section 23 within bracket 1 provides that where any senior citizen who, comma, after the commencement of this act, comma, has transferred by way of gift or otherwise, comma, his property, comma, তারপর ডাবল ইনভার্টের মধ্যে সাবজেক্ট টু দ্য কন্ডিশন দ্যাট দ্য ট্রান্সফারি শ্যাল প্রোভাইড দ্য বেসিক অ্যামিনিটিস অ্যান্ড বেসিক ফিজিক্যাল নিডস টু দ্য ট্রান্সফারার and such transferee refuses or fails to provide such amenities and physical needs, inverted clause, comma, the said transfer of property shall be deemed to have been made by fraud or coercion or under undue influence and shall at the option of the transferor, be declared void by the tribunal. Full stop. Thus, the very language of section 23 within bracket 1 does not provide does not require that the condition as to the transferee providing basic amenities and basic physical needs to the transferor needs to be incorporated in the gift deed itself. Full stop. Such condition, such prerequisite can even otherwise be proved by cogent evidence by the parties. Full stop. Next para. Insofar as the ratio laid down in Sudesh Chikara, Chhikara, Supra is concerned, the Honorable Supreme Court merely observed therein that for passing an order of cancellation of a gift deed under Section 23 of the 2007 Act, both the conditions as stipulated in the said provision are to be satisfied. Full stop. Next para. In what is the name of the judgment 2024?
Nasim Kaham.
Nasim Kahan. In the case of Nasim Kahan,
Kahanam.
Nasim Kahanam, Supra, the consideration before the Honorable Supreme Court did not arise out of the 2007 Act, and as such, the ratio laid down therein is not germane for the present consideration. Full stop. It is well settled that a judgment is only a binding precedent for what it holds and can be applied only under similar conditions. Full stop. Next para. That apart, the ratio laid down in Nasim Kahanam Supra has no applicability in the present context. Full stop. In the said judgment, the Supreme Court merely observed that for the purpose of construction stroke interpretation of the terms of a deed or document, the literal rule of construction should be applied first, and the intention of the parties are to be gathered from the clear and unambiguous language of the said document itself. Full stop. Only in the event when the language has any ambiguity can external aids be resorted to for such interpretation. Full stop. Next para. The question before this court is not about the interpretation of the gift deed or the purport of the same. Full stop. It is an admitted position that the gift deed was executed by the petitioner in favor of the opposite party. So what has been disputed is that the same was made to be was that the petitioner was made to execute the same under the impression that the transferee stroke opposite party, who is the son of the petitioner, shall provide the basic amenities and basic physical needs to the transferor, but has subsequently refused to do so. Full stop. There are two components in the said contention. Full stop. First, it had to be gathered by the SDO and thereafter the appellate tribunal, as to whether there was any such condition agreed between the parties, irrespective of whether such condition was stipulated in the deed itself or was evident from the conduct otherwise of the parties at the contemporaneous period, which can also be proved by oral evidence or by producing witnesses. Full stop. The second aspect is as to whether the transferee subsequently refused or failed to provide such amenities and physical needs. Full stop. Next para. In fact, a tacit acceptance of the second limb is found from the order of the SDO, since the SDO has directed maintenance to be paid to the petitioner by the opposite party. Full stop. However, in view of the above observations, it is clear that neither of the authorities concerned complied with the requirements to advert to the materials of the case and or grant opportunity to the parties to prove their respective cases under section 23 of the 2007 Act by cogent evidence. Full stop. Moreover, the impugned orders are devoid of reason, and as such, are palpably vitiated by law and principles of natural justice. Push up. Accordingly, CO number
36 of 2024.
thank you. CO number 36 of 2024 is allowed on contest, thereby setting aside the impugned order bearing order number 2 dated January 10, 2024, passed by the appellate tribunal under the Maintenance and Welfare of Parents and Senior Citizens Act 2007 of District Alipurduar in appeal petition number 09/2023, thereby affirming the order dated October 9, 2023, passed by the subdivisional officer Alipurduar in petition number 34/23 under the 2007 Act. Full stop. The matter is hereby remanded to the subdivisional officer, Alipurduar, for a fresh consideration on merits by granting adequate opportunity to both parties to adduce evidence in support of their respective cases. Full stop. Upon such opportunity being given and the parties being heard on their respective contentions, the subdivisional officer shall pass a reasoned order on the application under section 23 of the 2007 Act filed by the petitioner afresh. Full stop. It is expected that in view of the nature of the urgency involved, such exercise shall be concluded by the subdivisional officer within 6 months from the date of communication of this order to the subdivisional officer. No arrest to cost. Yes.
May be permitted to appear on behalf of the party. Otherwise, the SDO does not allow any lawyer to represent.
The Act does not permit.
So there
Is there any bar in the Act? There is a bar problem.
There is a bar, but subsequently.
Which is the section? Let us see. Yes, we sometimes. Judgments are there. Judgments are there.
Can appear, but.
Show me the section first. We have permitted advocates in several cases. 17. Actually. 1 minute, just. The specific bar, no party shall be.
So there, after this act, the Advocates Act was amended.
At this juncture, learned counsel will put it on both of you. Or a learned counsel for the parties seek liberty to be represented by legal practitioners before the SDO. Push up next para. Although section 17 of the 2007 Act debars parties to be represented by legal practitioners, keeping in view that both the parties are laymen in law and do not have any specialized knowledge of law, the parties are granted liberty to be accompanied by their agents, who may be legal practitioners, in order to assist the parties in making out their respective cases before the SDO. Your friends can go, they may be advocates and they'll assist. Yes. Mr. Sarkar, you argued very well. This was a very bad case. No, really, we're telling you, the case had no merits. You argued very well. Whatever points had to be covered, you covered. Yes.
11, this is my application.
Yes.
But this is my application. This is regarding transfer. Section 24, seeking transfer by the husband in a matrimonial suit filed by the wife on the ground of distance and manner I am in 80% handicap. Will not kindly come to.
This is appearing for the first time, Mr.
40.
Ghosh?
That
Appearing
is-
for the first time, Mr. Ghosh?
Yes, it's first time. This is the
What is
first
the
time.
suit for divorce
My
filed
lord,
by the
first
wife?
time.
Suit for divorce filed by the wife.
Suit for divorce filed by the wife. With the wife.
Acha, where is your
And I'm an
disability
80%
certificate?
handicapped person. That is an admitted fact. Wife
Where
also
is-
mentioned.
Where is your disability
Page,
certificate?
my lord, this
annexure
page
A1,
14,
page
page
14.
14, page 14,
Annexure A1.
page 14, page 14,
Your junior was to move the matter. Now I remember.
page 14.
Mr. Ghosh, your junior was to move the matter. Why did you move it? The petitioner husband
No, my lord, this is first time.
has sought the transfer of a divorce suit filed by the opposite party wife in the court of the learned district judge at Siliguri, which has subsequently been transferred to the court of the first court of additional district judge at Siliguri, to the court of additional district judge at Bankura. First up, the primary ground of the application, primary ground for transfer is that the petitioner husband is 80% handicapped, in support of which a disability certificate has also been annexed to the application. Pushed up, since a strong prima facie case for transfer of the suit on such
This
ground
is admitted in the petition.
has been made out, the present application is required to be decided on such question and the other grounds taken in the application. Full stop. Accordingly, the petitioner shall serve a copy of CO number 92 of 2025 on the opposite party, indicating how soon can you serve, Mr. Ghosh?
My lord,
When should I keep it next?
my lord, any day, my lord, in next circuit, any day.
Very well.
Any day at next circuit. My lord, am I audible? Any day.
Indicating that the matter shall next be listed before the appropriate bench of the next circuit, subject to being mentioned by the learned advocates for the parties. Full stop. An affidavit of service to that effect shall be filed on the returnable date. Full stop. There shall be stay of all further proceedings in matrimonial suit number 230 of 2024 pending before the first court of additional district judge at Siliguri, district Darjeeling, till disposal of the application.
I'm grateful. I'm grateful.
Next.
My fellow counsel is still engaged in the courtroom number.
You start the matter.
I've not been well versed with the matter today, so.
Get yourself well versed. If you are the advocate on record, you are his chamber junior, then.
So I've been practicing in Bombay High Court. I just recently joined in. It's been 3 days, so.
Very well. On the prayer of the petitioner, the matter is adjourned for the day.
Thank you, sir. Applies.
But tomorrow, don't say bye to court.
Yes, sir. Yes, sir.
But please prepare yourself. If on the next occasion your senior is not there, we'll take up the matter. You have to do it.
Oblige, Your Lordship.
Thank you. Next. Yes, Mr. Ghosh. Unholy nexus between. None appears for the parties at the time of call. First up, it transpires that on July 10, 2025, when the matter was last called on by in the previous circuit, none had appeared for the parties as well. First up, as a last chance to the petitioner to move the matter, the same is adjourned for the day. Ashutosh Bhattacharya is a regular of this court. Name is Ashutosh. I don't know him. Anyway. 18.
This,
Hearing of second appeal.
Second appeal was earlier admitted by your lordship and order dated 2nd August 2024.
Paper books have been prepared.
No. We mentioned this, since the execution case has been proceeded with, we are pressing the stay application, which is,
the stay was not granted at that. You had not filed an application, must be. That's why. Appeal admitted. What is the challenge? What is the appeal against?
Whether the appellant ought to have been treated.
Eviction suit.
Yes, licensee or a
licensee tenant.
Yes, we could kindly peruse the ground.
Yeah, the grounds will.
So that question itself was not dealt with.
Very well. In view of the appeal having already, you are appealing for the in this matter.
18, 19.
No, this is not.
19.
In view of the appeal being, in view of the second appeal having already been admitted on substantial questions of law, a strong prima facie case has been made out. You have asked for injunction. Fine.
Can and he treats this as an application for stay.
Very well. Execution case number you have given? No.
What is it?
But you have not even asked for regarding disposition. Only transferring alienating encumber. Mr. Ghosh, you have to file a proper application. At least nothing stated. File a one-page supplementary. You have connection with your client.
Yes, sir.
Very well. We'll keep it day after tomorrow. File a supplementary affidavit, and we are granting. I'm granting you leave to amend the prayer portion and the cause title. Injunction will be stay now, and the prayer regarding title execution case number and supplementary affidavit 1 page for introducing the fact that it has been levied execution. On the prayer of learned counsel for the না যেটা আগে বললাম কেটে দেবেন হ্যাঁ ওটা on the prayer of learned counsel for the appellants leave is granted to the appellants to file a supplementary affidavit and to amend the cause title and the prayer portion of the application in order to incorporate a prayer for stay of the connected execution case instead of injunction. Full stop. The matter be listed next on July 20. Should we keep it day after tomorrow? Can you do it in one day or Friday? Friday. Till on July 25, 2025, when it will be listed under the same heading. Mr. Mujumdar, you are there, but who is for the appellant? Petition. Oh, Mr. Ghosh is there. Yes.
I would be, Millard, I'm sorry, Millard, I would be embarrassing myself, Millard. I'm led by Mr. Sagor Bandyopadhyay. Millard, I have personally spoken with him, Millard. He has rushed to Delhi, Millard, for a matter in the Supreme Court today. He was supposed to come down.
You have informed Mr. Mujumdar.
Millard, I met him, Millard, 15 minutes back, not in the morning. Otherwise, I've told him. Millard, subject to Mr. Mujumdar's convenience, it can be taken up on Friday, Millard. Millard, he intends to come down physically and do the matter. He has earlier appeared also.
Depends on Mr. Mujumdar.
Convenience of the court is paramount.
No. What? You are always fair, but if you have any other difficulty, you are here in the circuit, during the circuit.
I have to be.
You have to be here, yes. Very well. On the prayer of the petitioner, let the matter stand adjourned till July 25, 2025. Appearance, please give all your appearances, Mr. Singh, and Anusay. আর কোনো পাঁচশো কিছু নেই চল বইটার ফাইল